And I believe the parties are calling a witness out of order. Is that correct?
Yes, Your Honor.
All right. Although Dr. Oziel is still on the witness stand and will be resuming the witness stand for further examination, the people at this point are calling another witness who will testify this morning, and when he completes his testimony, then we'll resume with the examination of Dr. Oziel. You may call your next witness.
People call Dr. Jeffrey Lulow to the stand.
Please raise your right hand with an affirmation. You can do that, raise your right hand. We do solemnly affirm that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth. This you do under the pain and penalty of perjury.
I do.
Please take a stand and state your name for the record.
My name is Jeffrey Lulow.
Spell your last name, please.
Lulow.
And your first name?
Jeffrey, Jeffrey.
All right.
Thank you. Dr. Lulow, what do you do for a living, please?
I am a psychologist
How long have you been a psychologist?
for 20 and a half years.
Excuse me, 20?
20, yes, sorry.
And in the period of time, 1986 through 1989, where were your offices located?
At 450 North Bedford Drive, suite number 203 in Beverly Hills.
On Halloween night of 1989, did you receive a phone call from someone that was known to you?
Yes,
And do you remember about what time of day it was that you received the phone call?
I may have received several phone calls. Are you referring to a particular one?
Yes, a phone call from Dr. Jerome Oziel.
I don't remember the time. I do remember it was dark and was after my children had returned from trick-or-treating.
Now, at the time, did you have small children under the age of about 8 or 9?
Yes,
Had you taken them trick-or-treating?
yes,
You were aware of the fact that it was Halloween?
I was aware.
Right. And when you got this phone call, do you remember where you were inside of your home?
No. I remember where I was sitting when I was speaking on the phone, but I don't remember where I was when the phone call came.
From where did you speak with Dr. Oziel in your home?
I had a phone at my desk in the living room.
And did you have a conversation with Dr. Oziel on the night of Halloween of 1989?
Yes, I did.
And at that time of 1989, approximately how long had you known Dr. Oziel?
I had met him in June of 1986, so that would have been about 3 years and a few months.
What did he say when he called you on the phone?
I don't remember the words specifically, but I do remember that he informed me that he called because he was concerned about an issue that touched on ethics and wanted to know if I could talk to him about it and see if I could help him out with it.
Then what happened?
I told him that I'd be happy to talk to him, words to that effect. And He told me that he did not want to tell me too much because he didn't want to betray a confidence that he had received in the course of his practice, and he did not want me to become involved in something that might potentially become dangerous.
At the time that you began to speak to him, did you notice anything about his demeanor over the phone? Did you notice anything about his tone of voice or anything like that?
Yes.
What did you notice, please?
I noticed that he spoke with some urgency. His words were clipped. There was some pressure of his speech.
After he told you that he didn't want to give you too much information, what next transpired during this conversation?
He told me that he had been seeing a young man who had told him that he and his brother had killed somebody.
Then what happened?
He asked if he had told me too much, if that was something that made me think I knew what he was talking about. And I said no.
Let me ask you a question. On August the 20th of 1989, approximately 2.5 months before, did something happen of significance in your own life?
Yes.
What?
My father died.
And at that time that your father died on August the 20th of 1989, were you present in the hospital?
I was present in the hospital for most of the week before that and dealing with the funeral for most of the week after that.
Did you read the newspapers during the period of time, the week before and after your father's death?
Apparently not. I don't remember too much else that I did. I went to the office when I could, and I dealt with the family matters of my father's health. And I don't remember too much else about that time. Apparently I wasn't reading papers.
When Dr. Oziel informed you that he'd had a patient who had made this statement that you related to the jury, did you connect that up with anything you'd heard about in the media?
I hadn't heard anything in the media people are in the media being killed all the time, every day, unfortunately, and that didn't make any particular connection to me.
Okay, now after that, what happened next?
He told me that one of these brothers had told him about having done this killing, and that the other brother, who was older, had come to his office apparently later, after he had first heard about this, after Dr. Oziel had first heard about this, and that there had been some talk at the office as to concern on these brothers' parts as to whom Dr. Oziel might tell about this, that it was no longer safe for them, that he had told somebody, and he had told them that because of the ethics under which he worked as a psychologist, he would not be able to tell anybody, and that he would not.
All right, then what happened?
He was concerned about two issues. Again, this is a phone conversation from 1989, so I remember the gist of it, but not the exact words. But I remember there were two issues he was concerned about.
And what were those two issues?
Oh, excuse me. I object to the question as made. Is he giving his impressions or what Dr. Oziel said to him?
All right, can you clarify that, please?
Okay, did you have discussion with him on two particular subject matters that you specifically recall?
Yes.
And what were the two subject matters that you specifically recall?
One had to do with his ethical responsibilities and the ethical constraints on him in such a situation. And the other had to do with his own safety and the safety of his family. Did
you and he address the issue of the ethics?
Yes.
And what was the conversation and what was your advice?
He brought up a case called Tarasov, which has to do with warning intended victims of violent crimes.
Now, at the time that he brought up the case of Tarasov, were you familiar with the Tarasov case?
Every psychologist has to be familiar with the case. I was very familiar with it.
And could you briefly tell the jury what your understanding of Tarasov was in 1989?
I'm sorry, I didn't hear you.
Could you briefly tell the jury what your understanding was of the Tarasov case?
Tarasov case, as I understood it, required, the outcome of that case required that a psychologist or other mental health professional take steps to warn the intended victims of violent crimes of their danger, and to alert the police or other law enforcement agencies that might be of help in preventing such a crime from being taken place. This was expanded in a later decision to include people who might potentially become harmed if this act is carried out.
All right. And
That was
in
the Headland case.
in the Tarasoff case, did that deal with danger to someone other than the psychotherapist or the patient?
Yes.
Did it deal with danger to a third party?
Yes, it dealt with danger to a third party.
And did Tarasoff indicate that if a psychotherapist did not warn a third party of an impending danger, that the heirs of that third party, should the third party be killed, could sue the psychotherapist?
That was my understanding, although I'm not an attorney.
All right. But that was your understanding as a psychologist, correct?
That was my understanding.
And you are, in fact, a psychologist and not a psychiatrist.
I'm a psychologist.
Okay. What else did you talk about with Tarasoff, with Dr. Oziel?
Well, he and I were discussing whether that case and the Headland case that I mentioned that expanded that to people who might reasonably be in danger applied when the intended victim is the psychologist or the therapist himself.
What else did you talk about?
Well, I said that I thought that it certainly was not going to extend more protection to someone else than it would to the therapist and his own family. And that I thought that the requirements of Tarasoff, in my opinion, as a psychologist, applied in this case, and that he could legitimately take steps to protect his safety and the safety of his family if he felt them to be in danger.
What else did you talk about?
We talked about what he could tell the police should he contact the police.
Now, who brought up the idea of talking to the police first, you or him, as best you can recall?
I don't recall.
All right. And so there was a discussion as to whether or not the police could be informed. Is that correct?
Yes.
And did you give him any indication as to whether or not he could ethically go to the police?
Yes, I did. I suggested to him that he could talk to the police, but he could not divulge to them the content of his discussions with these men beyond what was necessary to protect himself and his family.
Okay. Did you and he go into any details about how much detail he could tell the police?
I didn't want to know any more detail, so we didn't go into more detail.
All right. Did Dr. Oziel give you any indication about whether or not he wanted to go to the police or how he felt about that? Or did you have any further discussion along these lines?
Yes, we did.
I'm going to object to this, Your Honor, and so hearsay with no foundation.
Overruled.
We did talk about that. Dr. Oziel expressed a concern, a couple of concerns. One was that the police might not take it seriously enough, and secondly, that whatever protection they might offer would end at some point and that he and his family would still be in danger, potentially.
What else did you talk about?
I'm going to object to that, Your Honor. Calling for hearsay, no foundation.
Be more specific, please.
All right. I believe you indicated that Dr. Oziel had two concerns. One was ethical concerns and one was suggestions as to his safety. Is that correct?
That's correct.
Did you have any further discussion with him about the ethics of what he could do?
No.
All right. Did you have any further discussion about suggestions as to protective measures he might be able to take?
Yes.
Okay. And what else did you talk about in addition to talking about the police?
I'm going to object to that also, Your Honor. That's hearsay with no foundation.
Objection overruled.
I made a suggestion to him as to something he might do that would not violate the confidentiality of the discussions with these men and might also serve to protect himself and his family.
And what did you suggest to him that he do?
Well, I suggested a few things.
What's the first?
The first thing was that he tell his wife to take the kids and go on a vacation immediately.
Okay. What else?
That he hire someone to watch the house.
What else did you suggest?
That he hire someone to watch him, protect him, bodyguard.
Did you use the term bodyguard?
Yes, I believe so.
What else did you tell him to do?
I suggested that he write down in detail everything he had told me, plus whatever he had learned in the sessions from these men, that he put it in great detail, that he dated, that he put that writing in a safe deposit box.
Did you tell him what to do in regards to the safe deposit box?
Yes.
What did you tell him?
That he provide his attorney with a key to the box, with the right to open the box, that he sign whatever he needed to do to let his attorney open the box, that he also directed his attorney that if anything should ever happen to him or his family, that the attorney was to open the box in the presence of authorities.
Did you give him any suggestion as to whether or not he should convey these measures to the people who had threatened him?
I specifically suggested that he tell these men that he had done that, so that with the idea being that they would recognize that his safety was their concern, that they would be better off if he were safe, but also indicating that by doing it in this way, he had not divulged the confidence.
Now, at the time that you had this conversation with Dr. Oziel, do you recall if all the Halloween activities were already over?
We always had stragglers coming in trick or treat. They always seemed to be older than the kids who came earlier, and so we had people coming to the door now and then.
Was that after the phone call with
Object
Dr.?
to this is irrelevant.
It's just pin the time, Your Honor.
Overruled.
I don't recall precisely if anybody did come on that night or not. We generally did, but I don't know.
All right. Dr. Lulow, when was the first time you were contacted by any of the attorneys in this case regarding the activities of Halloween of 1989? And by whom were you first contacted?
I was called on, if I can look at my appointment book, I can probably tell you the day.
All right. Do you have your appointment book?
Yes. I believe it was Wednesday, August 4th.
Do you remember who it was that called you?
I didn't get his name completely. Mr. Burke, is that the name? Represents Lyle Menendez, he told me.
All right. And that was the first phone call you've gotten from any of the attorneys in this case. Is that correct?
That's correct.
And then you were called subsequently by either myself or someone on the prosecution team. Is that correct?
That's correct.
So your first contact then was from the defense, correct?
That's correct.
Now, how was it that you knew Dr. Oziel?
I have a concern that divulging that may violate a confidence. I'd rather that the court tell me whether or not I can divulge that.
Does this have to do with probationary status of Dr. Oziel?
Yes, it does.
Okay, you may.
I'm ordered to do
Yes.
so. Thank you, Your Honor. I was selected by Dr. Oziel to supervise him when he was on probation with what was then called the Psychology Examining Committee, and now is called the Board of Psychology.
And in that regard, were you employed by the Board of Psychology to conduct the supervision, or how were those arrangements made?
The Board of Psychology apparently provided Dr. Oziel with a list of psychologists from whom he could select someone as his supervisor. He selected me, and he would be paying me for the time involved in the supervision.
Did you first meet with him in June of 1986 in regards to his probationary status?
Yes,
And did you conduct interviews or sessions with him for once a week for a period of a year after that?
yes, I did.
What was he on probation for?
Again, Your Honor, is that something I can answer?
Yes.
He was on probation for what's called a dual relationship. He had had a relationship with a patient, and it.
Your Honor.
Okay, let's hold on. We're having some electronic problem here.
Can get some water?
Sure. Get a little water for you. Well, how is the reporters, well, we're working now? Lynn, or?
Does this microphone need to be positioned differently?
No, you're okay. It's just some hearing device for one of the jurors. You okay? Okay, let's go. All right, you may resume your examination.
I believe the question was, what was Dr. Oziel on probation for? Could you factually explain what it was?
He had a patient whom he was seeing, who said he was unable to. Thank you. Was unable to pay Dr. Oziel's bill, and after some discussion with this patient, Dr. Oziel had arranged with.
At this point, I'm sorry. You can do it. I'm going to object to this as you're saying. I'm going to
Details of it are sustained.
Okay. Did Dr. Oziel
Go
tell
ahead.
you?
Your next
Dr.
question.
Oziel tell you what he was on probation for?
Again, Your Honor, is that something I can divulge?
Yes.
Dr. Oziel did tell me what he was on probation for, but I had also received documents from the Psychology Examining Committee telling me.
And did he was on probation for having a patient do work on his home in lieu of paying for services. Is that correct?
Objection, Your Honor, that's hearsay.
Sustained.
What did Dr. Oziel tell you he was on probation for?
Objection, hearsay.
Prior consistent statement.
Okay, counsel, let's not argue the matter. The objection is that this is hearsay. It's being offered for the truth, is it?
Yes, as a prior consistent statement.
All right, the objection is overruled. You can answer the question.
Dr. Oziel told me that he was on probation. Wait, well, I forgot what the question was.
Okay.
I was answering some other question.
Very briefly, okay, very briefly. What did Dr. Oziel tell you as to why he was on probation?
He had a patient of his do some work on his house while the man was still a patient,
In lieu of being paid money?
in lieu of paying Dr. Oziel's fee.
Did you write 4 quarterly reports on Dr. Oziel's behalf?
Yes, I did.
Objection, relevant.
Overruled.
And were these reports favorable?
Objection, hearsay.
Sustained.
Did you recommend the successful completion of Dr. Oziel's probation?
Objection, hearsay.
Sustained.
May I make an offer?
Yes, you can do that at the sidebar.
Yes.
All right, you may continue your examination.
Dr. Lulow, I believe you indicated that you first met Dr. Oziel in June of '86. Is that correct?
That's correct.
Now, in October of 1989, jumping ahead some period of time, how long had it been since you had seen or heard from Dr. Oziel?
I had heard from him, I believe, the previous summer, but I don't remember when. 1989.
Okay, and prior to that, how much contact had you had with him?
Had not heard from him since I stopped supervising him in June of '87.
Okay, I have no further questions of this witness.
Cross-examination.
Dr. Lulow, I noticed when you were asked the question of when you and I spoke, you had a book in your hand that you looked at, and you then gave us the date of August 4th as the date when you and I spoke, correct?
Are you Mr. Burke?
Yes.
Oh, okay. I don't know who you are.
I'm sorry, I'm Mr. Burke.
Yeah, that was my best estimate. I don't enter it in the book. I was trying to remember by whom I had seen that day. So it may have been the day before or the day after. I don't recall.
Did you make any notes of the conversation you say you had with Dr. Oziel?
Which conversation?
Well, the prosecutor questioned you about a conversation on Halloween, and you explained how you were out with your kids trick-or-treating. So that's the conversation you're here to testify about.
Okay.
And my question was directed to that conversation.
Made no notes.
Made no notes. And you at that time were Dr. Oziel's, in effect, probation officer, were you not?
I, at that time, had no connection with Dr. Oziel whatsoever.
When did you become Dr. Oziel's probation officer?
Well, I was never his probation officer. I was his supervisor.
He was on probation.
That was not a matter between him and me. I was his supervisor. That was the role that I served.
Was he on probation? Was that your understanding?
I don't recall the details of that, whether it was probation or whether his license had been revoked and it was stayed. I don't recall the details.
Well, what was your understanding of what you were supposed to be doing with him?
My understanding, during the time that I was supervising him,
Yes.
I was supposed to be, in effect, monitoring his practice, both in terms of the nature of what he did in his practice and any ethical considerations that came up, and reporting to the Psychology Examining Committee quarterly regarding these meetings.
And was it your understanding of your relationship with Dr. Oziel that he was going to be looking to you for advice on certain ethical questions that he might have?
During the time that I was supervising him?
Yes.
Well, he could look to me. He could actually talk to any of a number of people. These sessions were a weekly thing, so it was an easy thing if there was an ethical question that came up to ask me about it and to discuss it with me.
And I think you said you first began seeing him on probation on June 2nd, 1986. Is that?
I don't recall the date that I did it. It was in June of '86. I do know that.
And when did you stop seeing him?
It was a 1-year period of supervision that he had to have. So I believe it was either the end of May of '87 or the beginning of June.
And after that period of time, I think you indicated you had no further contact with him. He never called you again?
He didn't call me until sometime in the summer of '89, I believe it was. That's an imprecise time in my mind.
So after your involvement with him in May of '87, the next time you heard from him was in the summer of '89?
That's correct.
And was that the telephone conversation on Halloween night?
No, Halloween's in the fall.
That's true. What was the conversation you had with him in the summer?
He asked if I could refer him to a psychiatrist or psychologist to help him with the matter that he was involved in.
And did you in fact refer him to a psychiatrist or a psychologist?
Both.
And who did you refer him to?
Dr. Franklin Drucker, psychiatrist, and I believe Dr. Bruce Sutkus, Sutkus, a psychologist.
And then the next time you heard from him was in October of 1989?
That's correct.
Now, have you been in contact with him since that conversation in October of 1989?
I believe I had, you asked me this on the phone, and I said at the time, and what I said at the time to you was that I'm not clear. I think I did have one further conversation, but I don't remember it. I don't remember anything about it except that I talked to him, and I think his wife was also on the line.
And have you seen him socially at all since then?
I never saw him socially ever.
This information you say you gave to him, you told him that his wife should go on vacation. Is that right?
I suggested that his wife and children, whoever was in the household, should go somewhere else until things had settled down, yes.
And by the way, that's not information you provided to me when you and I spoke, was it?
I answered all your questions when you asked them.
By the way, that's not information you provided to me when we spoke, is it?
No, I didn't give you any information you didn't ask for.
And again, once again, you did not give me that information that you told him that his wife should go on vacation. Yes or no? It's very simple to answer.
No, as I said before,
Thank
no.
you. And you didn't tell me in that conversation that you advised him to get a bodyguard, did you? Yes or no?
I don't recall whether I told you that or not.
Did you tell me in that conversation that you advised him to write down in detail everything he did?
I don't recall what your questions were. I know I answered your questions. I don't recall whether you asked me that or not.
You recall telling me that there were certain things that you would not discuss with me?
Yes.
And was this one of the things you didn't want to reveal?
I didn't think that I could talk about the content of any of my supervisory sessions with Dr. Oziel.
Right, but
That's what I had in mind when I said that to you.
Yeah, but you were free to tell that to the prosecutor. Is that
Free
your
to tell what?
understanding?
I'm sorry, free to tell
You
what?
were free to tell the prosecutor that information?
Of course not.
Didn't you meet with the prosecutor before you came to court
Yes.
today?
Yes.
And didn't you tell her this information that you just revealed to the jury?
Could we have it clarified what information you're talking
The
about?
information about advising Dr. Oziel to get a bodyguard?
Now, you're mixing two things up.
Did you tell her the information about advising Dr. Oziel to get a bodyguard? Yes or no?
Yes, I did.
All right. And did you tell the prosecutor the information about advising Dr. Oziel to write down in detail everything he did?
Yes.
Did you tell the prosecutor that you advised Dr. Oziel that the police could, in your opinion, be contacted under the Tarasoff decision?
I think I said, yeah, I told her that. I think I told you that too.
All right. Now, was it your understanding when Dr. Oziel called you that his ethical dilemma was he wasn't sure that Tarasoff extended to a situation that involved a threat to the therapist himself?
That was part of his concern.
All right. Did he indicate any misunderstanding that Tarasoff did or did not apply to a threat to someone else?
My recollection is that he understood that Tarasoff applied if someone told him they were going to do harm to somebody else, period. And that under those conditions, he had a duty to warn the person But when the threat was to himself, he was unclear.
All right. So if the threat was to a third person, at least based on your discussion with him, he understood that it applied there. The ethical question was, well, what about if the therapist is threatened?
That was one part of the ethical question. The rest of it was what could he divulge in order to protect whoever had to be protected. Some of this was really an airing of views more than seeking my word. I didn't have any authority to tell him. It was just airing the views and getting my suggestions.
And you basically, if I understood your testimony correctly, told him that he could divulge to the police whatever was necessary to protect himself or his family, correct?
Only that which would be necessary to protect
Himself and his family.
Yes.
And he never discussed with you that there was anyone else involved besides himself and his family, did he?
I think he had a housekeeper. I kind of assumed that person, if he did have a housekeeper, would be included at the household.
In other words, he mentioned that there was a housekeeper that may have been in danger as well.
No, he didn't at that time. But when I was supervising him, he had mentioned the presence of a housekeeper. So when I talked to him in '89, I figured there might be a housekeeper. So that person was in my mind as well.
And did you mention that? In other words, as you were discussing the situation, did you say something along the lines of, well, you can do whatever it takes to protect yourself, your family, your housekeeper, whatever?
No, I never said you can do whatever it takes. I never said that.
Did he mention to you that he had a girlfriend that he was worried about?
Never heard any mention of a girlfriend.
Did he mention to you that there was a girlfriend sitting in the room with him as he was discussing the confidential information that he was discussing with him?
As I just said, there was no mention of girlfriend in any relationship to anything at any point at any time between Dr. Oziel and me in that conversation.
And so he never mentioned any ethical problem with regard to divulging any information to a girlfriend or anybody like a girlfriend,
I
right?
think that goes without saying based on my last response.
All right, you can just answer the question, okay?
I think I did.
Good, thank you. Now, did you indicate that Dr. Oziel said to you that he had told the patients that he couldn't tell anyone what they had told him?
That he had told them that he couldn't tell anybody about having told him they had killed somebody.
Basically, he explained to you that he had explained to the patients that what they had said was confidential.
Yes.
And that was all he said about what he had explained to the patients about confidentiality, right?
That's correct.
And when you and I spoke on August 4th, did I tell you that for the first time since this litigation began in 1989, Dr. Oziel mentioned your name for the first time in testimony here before this jury?
Objection, hearsay, irrelevant, what he said.
Just for a non-hearsay purpose. Were you aware that your name came up in this case for the first time the other day in front of the jury?
I have no idea when my name came up or didn't come up.
And prior to my calling you on August 4th, did Dr. Oziel ever contact you and say, I want you to testify in a hearing or before a court to explain to the court that you were the one that came up with this idea about?
Never. I haven't spoken with Dr. Oziel for years.
And do you know if Dr. Oziel followed your advice that you gave to him
I
about
do
hiring a bodyguard? And
I do not know.
thank you. That's all I have. Dr. Oziel ever express any concern for his business partners?
Objection, Vegas, is October 31st.
October 31st.
I don't know whether he had business partners nor whether they were threatened.
So you don't have any specific recollection of him saying to you, I got people in this office who are also threatened. What do I do about them? Words to that effect.
I don't remember him saying words to that effect.
Do you know who supervised Dr. Oziel for the remainder of his probation?
I don't know whether there was any remainder of the probation.
What was your understanding as to how long the probation was when you were dealing with him? Was it 5 years?
1 year.
I think that hearsay, I'd object to hearsay.
Overruled.
My understanding was that I was to supervise him for 1 year.
What did you do to supervise him?
I met with him weekly, discussed, without divulging any details of that had been given to him, issues that may have come up in his practice that were ethical, discussed some ethical issues that may have come up in my practice as illustrations. That was what we did.
And then he was to pay you a fee for your time,
Certainly,
is the way that worked.
certainly.
Thank you.
Ms. Aberson?
Thank you.
Dr. Lulow, as part of the discussion that you had with Dr. Oziel, did you advise him to tell these patients, these particular two patients, that since confidentiality was limited and since they had threatened him, there was no further confidentiality?
Let me think. I know I didn't say that.
Wouldn't that, in your opinion, have increased any potential danger, assuming there was any?
Objection calls for speculation.
Did you have any such opinion at the time?
I did not have the opinion that confidentiality had gone out the window with the threat. That was not my opinion at the time. Again, I'm not an attorney. I'm a psychologist trying to deal with a problem with another psychologist.
I'm trying to focus you, though, on the advice that you gave Dr. Oziel about how to take some measures to make himself feel safer, okay? You had suggested that he write detailed notes, that he put them in a safe place, that he give an attorney access to them, correct?
Correct.
And you also advised him that he should tell the patients, basically, I have these notes, therefore it's in your best interest if nothing bad happens to me, in effect.
In effect.
And he told you that he had assured the patients of confidentiality, and that too was a safety effect, was it not?
He told me that he had assured them of that, but my understanding from what he told me was that he assured them of that before the threat was made.
Okay. And did he tell you that he had no further conversation with them about confidentiality after the supposed threat was made?
I'm sorry, there was a cough there. I couldn't hear.
Did he tell you that there was no further discussion about confidentiality after the supposed threat was made?
We didn't talk about anything else about that session or sessions he'd had.
Okay. You were supervising him to monitor his ethics, is that right? Because his violation was an ethical violation.
Yes.
You weren't there to supervise his competency, were you?
Well, only as ethics touch on competency, of course.
Okay. But you weren't, for example, privy to his patient notes. You weren't reviewing whether his therapeutic contracts or assessments or diagnosis or therapeutic plans for each of his patients were fit the standard of care for competent practice.
Only insofar as that information, in a very vague sense, became relevant to discussing ethical issues.
Do you recall how many patients Dr. Oziel had in 1986 through 87 when you supervised?
Objection calls for hearsay irrelevant.
Overall?
I have no idea how many patients he had.
Were you aware in 1987 that he went into business with a patient?
Objection calls for hearsay. Hearsay.
Objection overruled.
I know nothing about going into business with a patient.
If he had gone into business with a patient, would that have caused you some concern given the fact he was on probation for a dual relationship?
It would have given me concern for anybody, whether or not they're on probation. You're not to do that.
Now, when you and Dr. Oziel were discussing Tarasov, well, let's try that. You've testified you told him he could divulge to the police what was necessary to protect himself. Now, that's the standard of Tarasov, isn't it? You divulge what is necessary to protect.
That's my understanding.
Okay.
Yes.
And Tarasov basically is the case that established civil liability, the ability to be sued and pay money if a therapist fails to warn a third party that they have been threatened by a patient.
That may be its import for the law. The import for psychologists is you've got to warn and you've got to protect.
Okay, but it has two impulses. One is, what Tarasoff really said was, if you don't warn, you can get sued. You can be held responsible.
That's a legal understanding of it. My understanding was you got to warn, you got to protect people.
Okay, you also have to have malpractice insurance, don't you?
I don't believe you're required to.
But I'm saying if you're concerned about Tarasoff, that's a concern that leads to malpractice insurance because you could get sued for a lot of money.
I don't know. I have malpractice insurance because I think it's a good thing to have.
Okay. Do you know if Dr. Oziel had malpractice insurance?
That's irrelevant.
Sustained.
Now, you told him to write detailed notes. Did you intend that he should write notes that were accurate?
Certainly.
And is it your understanding as a psychologist that notes are likely to be most accurate when they are written closest in time to the events that they detail?
Objection beyond scope.
Overruled.
It's an interesting question. It actually has two parts to it as far as the psychologist is concerned. With respect to the actual words that are said, it's probably, I'm sure it's more accurate closer in time. But in terms of an understanding of the import of what somebody says, very often that becomes clearer as time passes.
And as you have more contact with the person. Is that
Well,
right?
sometimes just thinking about it.
Okay.
Sometimes just having your own experience that touches on the issue.
But the practice of keeping notes, psychologists keeping notes, okay, is there some ethical notion that they should be an accurate reflection of what goes on with a patient in a therapy session?
Well, again, there's two questions there. I'm not aware of any requirement regarding the keeping of notes. That's an issue that is being hotly debated in psychology at present. What standards, if any, should there be for note-taking? But certainly, I think it's only reasonable to require that any notes that one takes be accurate.
Did Dr. Oziel indicate to you that he was going to follow that piece of advice and sit down and write detailed notes?
He said that he thought it was very good advice and that he was going to do that.
Are you familiar with any of the research in memory and the retention of memory over time?
Your Honor, this is beyond scope.
Objection sustained.
Did Dr. Oziel indicate to you before you got off the telephone with him that night that he was going to call the police?
I don't recall whether he indicated that he'd call the police, that he would call the police or not.
Thank you. I have nothing further.
Any redirect?
Just briefly, Dr. Lulow, I believe it was your testimony on cross-examination that you did not make any notes of this conversation. Is that correct? The one from October the 31st?
That's correct.
And yet, do you remember the conversation?
Oh, yeah.
Argumentative.
Overruled.
I do recall the conversation.
How come?
It was a dramatic conversation. It was reinforced in my memory when I saw a news report on CNN in March of 1990.
Was this a unique type of conversation for you to have with another psychologist?
Was unique till yesterday when I had another such conversation.
But up until yesterday, was this a unique experience for you?
Up till yesterday, it was unique.
Thank you.
Anything else?
You say you saw something on television which reinforced the importance of this in your mind.
Yes.
Did you at that point think it was important enough to come forward and tell people you had some information regarding this case?
Did I think it was important enough to, cause two questions. I thought it was important. I didn't think that I as a matter of fact, I was watching CNN with my attorney. And my understanding was I had no responsibility to do anything at that point.
Or at any point?
At any point. Except to come here when I got a subpoena.
Now, I want to clarify one thing. Did you tell Dr. Oziel that he should write down immediately his impressions?
I don't recall whether
Overruled.
I don't recall whether I suggested a time frame. I suggested a course of action that at the time I thought made sense.
And in terms of the conversation you had with him in this specific situation, you testified that sometimes your impressions as a therapist will get better with time. Is that the same situation as someone who comes in, say, and threatens, and you're trying to document what the circumstances are of that threat?
If you're
Or are you talking in terms of a diagnosis or evaluation of the
Right.
patient?
Right. I'm saying that what I said was that I think that in terms of the specific things that were said, it's probably more accurate right after. If that's what I'm doing in my notes, then I would want to do it right after. If what I want to do is try to understand it, I might not want to write anything down for a little while.
Okay. And so in a situation, say, where there's a threat made, because of the ethical ambiguity of what a therapist can do, it might be important to sit down and get the actual words of the threat down right away, because that's something that maybe is going to come into play later in terms of what the therapist does in terms of warning and disclosing and whatnot, correct?
I don't know. My understanding is I'm not here as an expert witness on memory. I would write it down right after.
All right, anything else? Okay, thank you. You may step down. You're excused. All right, let me see counsel at the sidebar regarding the next examination. Sure. All right, we'll take a recess then, ladies and gentlemen, until 11 o'clock. I was just conferring with the attorneys regarding the scheduling and as far as what we're next doing here. And since there is going to be some examination of Dr. Oziel before only one jury and not the other jury, I was trying to ascertain from the lawyers when precisely we'll do that. But there is still further examination of Dr. Oziel before both juries. And because of that, we'll proceed with that next. And that will be examination by the prosecution called redirect examination. So we'll take a recess and we'll resume at 11 o'clock. Don't discuss this case with anyone. Don't form any final opinions about it. And we'll resume at 11 o'clock. Juries are not yet present. Counsel had a matter that they wanted to discuss before the juries come in. And that had to do with one document that people intended to offer. Is that right? All right. What is the offer of proof in regards to that particular document? Why is it relevant?
Well, with respect to this document, Dr. Oziel's credibility, I think, has been questioned by the defense. In particular, they claim...
What makes you say that?
In particular, the defense claims that Dr. Oziel was obsessed with Judalon Smyth. They have gone so far as to play tape recordings of him calling her up. These documents indicate the nature of the initial call from Judalon Smyth to Dr. Oziel, which was business in nature. That is, she solicited Dr. Oziel's business.
No, I'm just asking about that second document dated 7/18/89.
With respect to that happens to be a medical report. My understanding is that Judalon Smyth, as Dr. Oziel has testified, was obsessed with Dr. Oziel. She wanted to have sexual relations with Dr. Oziel. Dr. Oziel at that point said, I have a wife. I don't want to endanger my wife. Judalon Smyth at that point presented him with a doctor's report indicating that she was HIV negative. That goes hand in hand with him saying that she was obsessed with him. The following letters are just a sampling of letters that Dr. Oziel received, in which Judalon Smyth professes her undying and timeless love for him. And they're an indication of his state of mind. That is, he's basing his state of mind, his testimony from this witness stand, that he believed that she was obsessed with him based on some of these letters. So I think they're highly relevant in this case. And in as much as the defense has injected the relationship into the case, I think that in order to rebut their claim that she or he was obsessed with her by way of even these tapes that they presented to the jury, I think we have a right to counter that with the indications in these letters which indicate that she was obsessed with him. And I don't think it'll take very long. I will just question.
Okay, again, we're not talking about the letters, we're talking about just this one document. So you indicate that it has something to do with her state of mind.
Exactly. In fact, she indicated to him that she wanted to have sex with him, and he required that she present him with indications through medical records that she was not, or that she was HIV negative. So I mean, I think that's highly relevant in her pursuing him as he has testified.
If I might.
And also, Your Honor, I
Yes,
think, if I may, I think that there are women jurors, and this is my own belief, women jurors on these panels who would find it horrible that a married man would have sex with another woman in an affair without taking measures to protect his wife.
And that's what would cause them to have this response, the absence of a test. Otherwise, the jurors wouldn't have that reaction.
No, I think that this shows, and the reason why I think this is important is that the jurors are just regular humans. They have their own feelings about things. And I think that once they find out that Dr. Oziel obviously had these extramarital affairs, but he took steps to protect his wife. And I think it's important for the jurors to know that.
All right, what is the defense response?
Well, I just want to make it clear that we did not inject his relationship with Ms. Smith. He offered that as a reason why he disclosed to her. Otherwise, I think the court has a decent sense of people's privacy. I don't think I have to address that in court.
Basically, the defense position is it's an invasion of Ms. Smith's right of privacy in regards to this. It's a negative test. It's not a positive test, so it doesn't disclose anything of her character or nature that is something that would cast her in a bad light because of the result of the test in any way.
But it's still awfully sleazy to get down to AIDS testing in order to dispute the nature of the relationship. They have their little pile of letters and we have ours.
Right.
I mean, you really want to get, pardon me. I mean, if we're gonna start fighting out over who's had medical tests, it seems to me that's gonna swing the door wide open, anything goes. By way of proof of who cares about whom and at what time. I mean, he said that in October, he was trying to get away with her. He does not claim that in July, he was trying to get away with her. He says he knew her a month before the sexual.
Okay, let me stop here. I suppose we can have some expert witness come in and testify to the etiquette involved in such relationships, if there is such, and what the custom and manner in the community is as far as how often these tests are run. They're done on a weekly basis or a monthly basis. I don't know, maybe we can get an expert testimony in that regard. But really, the probative value of this is nil at this point. It doesn't show anything, it doesn't prove anything. So I'll sustain the objection. If it becomes relevant during testimony of Ms. Smith, then it could be revisited at that point. But those two documents relating to the test at this point don't really prove anything.
Would he be able to testify that he took measures to protect his wife? However, if the court is going to exclude these, I suppose.
Do you really want to go into the details of the sex activities and things of that nature? Is that really how you want to approach this?
Well, Your Honor, with respect to the
We have no
sleeves, they've injected this into the case.
We have no
injected this into the case.
Oh, sure, let the sleeves fly.
That's what they would prefer. I would like to just handle it just with this exhibit and some short testimony. Let's get on to the real issues of the case. I mean,
All right.
they would like this to be a sideshow with Judalon Smyth.
Well, we can, I suppose what the people are trying to show is that he is a wonderful husband and father. We are more than happy, eager to litigate that issue. And then we can ask him if he had all the other women that he was having affairs with who were living in his home tested for AIDS. I suppose we can ask if he wore condoms. I mean, I think it's getting a little far afield.
I agree. But, there has to be some limit to the area of examination here, and we have so far refrained from getting into the specifics of such activity, and I don't see any reason to do that at this point. So the objection is sustained. I don't see any It doesn't seem to be relevant, appropriate of any issue.
With
Right.
respect to these two cases.
Yes, the other documents all seem to be relevant and can be used as ever you choose to use them. All right, are we now ready to have the juries come in? All right, let's have both jury panels come in, please. And would you state your name again for the record, please?
Dr. L. Jerome Oziel.
And this will be a redirect examination conducted by Mr. Kuriyama before both juries. Yes.
Dr. Oziel, I'm going to show you what's been marked as Exhibit 110. You recognize that?
Yes, I do.
Is that your curriculum vitae?
It's an outdated curriculum vitae, but it is a curriculum vitae. That's
What do you
correct.
use a CV for?
Well, a curriculum vitae is really the statement that somebody who's in an academic profession tends to use to summarize the data that allows someone to know what they've accomplished and achieved in their academic career. So that's ordinarily the purpose.
Now, in cross-examination, the defense went over selected parts of your CV with you, correct?
That's correct.
There are parts that they didn't go over.
They didn't go over the vast majority of it.
Okay. For example, you were honorably discharged from the Army in June of 1968.
That's correct.
You received your bachelor's degree in psychology from the University of Washington.
That's correct.
You received your master's in clinical psychology from Xavier University in Ohio.
That's correct.
You received your PhD in clinical psychology in 1972 from Arizona State University at Tempe.
That's correct.
That in 1971-72, you received the Letter of Distinction in Doctoral Comprehensive Examination from Arizona State University.
Yes, I did. I think as I recall, I received the highest rating or distinction among all doctoral students.
And in 1972 to 1974, you were the assistant professor at the University of South Carolina in their Department of Psychology.
That's correct.
And in 1974, you were the assistant professor at the University of Southern California in the Department of Psychiatry and the Allied and Behavioral Sciences in their School of Medicine.
That's correct.
And in 1980, you were the associate professor of psychiatry, and you were a tenured professor, correct?
Yes, I received tenure at the university.
At the University of Southern California Department of Psychiatry and the Allied Behavioral Sciences.
That's correct. I did.
Now, when you first started to see the defendants in October of 1988, what was the nature of your practice?
The nature of my practice was actually family and relationship therapy, in addition to the treatment of phobias, sexual disorders, and anxiety disorders. But one of my licenses is in marriage, family, and child counseling. And in fact, I co-directed a clinic in the Department of Psychiatry at USC, which was the sex therapy and relationship counseling clinic, which includes family therapy. And I taught and trained psychiatry residents, interns, medical students, nurses, and a number of other professionals, such as social workers and some staff members, in the performance of relationship therapy, in addition to the performance of behavioral therapy in relationship to treating depressions, phobias, obsessive compulsive disorders, and other anxiety-based disorders.
Generally speaking, as part of your practice then in 1988, did you, as part of your practice, treat adolescents with behavioral problems?
Yes, I did.
Now, is your wife Laurel Oziel?
Yes, she is.
And is she also a psychotherapist?
She is.
And during the period of time of 1988, around 1988, did she share office space with you?
Yes, she did.
How long has she been practicing as a psychotherapist?
Approximately the same amount of time as I had.
Now, do you share office space? Do you also share billing, people that do the billing for you?
Yes, we do.
And is she more involved in the billing aspect of your practices?
She's almost totally involved in the billing aspect of my practice, deals with that with whatever secretary is employed there. I have very little, if anything, to do with it.
With either the billing or the secretaries?
That's correct.
Okay. So your wife is more involved in keeping of the books, et cetera?
That's correct.
Now, recently, were you in the process of moving your residence without telling us where you've moved?
Yes, that's correct.
Have you placed a lot of your records in boxes?
There are a lot of things that we have in boxes that we have not unboxed.
Now, while teaching at the University of Southern California Medical School, in the Department of Psychiatry, you indicated that you were a co-director of some clinic?
Several clinics.
Several clinics? Was
Yes.
one, what were those clinics?
The clinics were the anxiety disorders and the behavior therapy clinic, and also the sex therapy and relationship therapy clinic. Those are the two clinics that I co-directed in the outpatient department of psychiatry at USC.
You've testified from Exhibit 97, some records of billing in this case. And with respect to that, may I approach, Your Honor?
Yes.
I'll show you what's been marked as Exhibit 97, billing records.
Mhm.
Being examined from those records, you indicated that you had contact with Mr. and Mrs. Menendez, that is Jose and Mary Louise Menendez.
Yes.
What was your impression about Mrs. Menendez in your conversation with her?
Your Honor, I'm going to object to the adequate foundation.
That is,
Sustained.
did you actually see Mrs. Menendez on September 30th, 1988?
I'm sorry, did I see Mr. Menendez?
Mrs. Menendez.
Mrs. Menendez? To the best of my recollection, I did.
So did you see both Mr. and Mrs. Menendez on that day?
To the best of my recollection, I did.
You've testified in cross-examination what your impression was of Mr. Menendez. What was your
Objection,
impression?
Your Honor, that misstates the evidence. He's asked for the remote.
All right, the objection is overruled.
Did you, all right, did you like Mrs. Menendez?
Yes, I did like Mrs. Menendez.
And what was your impression of Mrs. Menendez?
Objection, Your Honor, no foundation.
Overruled.
My impression of Mrs. Menendez was that she was a very bright, educated, sophisticated woman who was extremely protective.
Objection, Your Honor. We're going to get into content I'd like to be heard.
The objection is sustained. The question relates to the impression he had of her as a person, not any thing she did, just the impression you had of her as a person, similar to the impression you had of Mr. Menendez that was described by you.
Your
So
Honor,
the objection is sustained, the answer is stricken.
I'm just asking the court for clarification. In my view, that was part of my impression of her. I'm not sure how to segregate the two.
All right. Why don't you rephrase the question then?
What impression did you form of Mrs. Menendez based on what you saw of her?
Same objection.
All right. Not in relationship to other people, just as to Mrs. Menendez as a person.
Her individual personality
Yes.
characteristics. Okay, thank you, Your Honor. That she was very passive and anxious and depressed and just not very efficient or fulfilled as a person. So there was a very
Your Honor,
big.
I'm going to object to this as expert opinion with no foundation. People have indicated they did not call this one.
Right, counsel. Let's not argue the matter. The witness is being asked to give a personal impression of the witness, not as therapist or a psychologist, just your own personal impression of the witness.
I'll ask another question, Your Honor.
All right.
Did you like Mrs. Menendez?
Overall,
Yes, I did.
Now, were Mr. and Mrs. Menendez patients of yours?
No, they were not.
About October of 1988, you started to see the defendants in this case, correct?
That's correct.
And the exhibit that you have in front of you, the billing records indicate when you first started to see the defendants. Is that correct?
That's correct.
You were asked many questions about that particular exhibit. I'm going to ask you to take a look at the entry for August 18th, 1989.
I have that.
What does that indicate, that entry?
It says, canceled short notice, Eric.
Now, on that day, were you made aware of why the cancellation took place?
No, I was not.
Eric Menendez didn't tell you that he was going to go down to San Diego to buy a shotgun?
Your Honor, that's,
objection overruled.
excuse me, ma'am, you first.
Objection overruled.
You may answer, Dr. Oziel.
There's no foundation that he even spoke to Mr. Menendez.
Objection is overruled.
The answer is no. Eric definitely didn't tell me he was going down to San Diego to buy shotguns.
Sometime after August 18th, 1989, did you find out that Mr. and Mrs. Menendez had been killed?
Yes, I did.
And sometime after, well, do you recall when it is that you found out that they had been killed?
I think the first time that I found out they had been killed was actually, I don't know if I was home or phoned home or whatever, but Laurel, my wife, said, my God, you know, I'm just watching TV.
Objection, hearsay.
The question was when or how?
Actually asked when, Your Honor.
Okay.
When?
The objection is sustained. The answer is stricken.
Okay.
The question is, when did you find out?
Yes, I believe it was the day that it was reported on the news, whatever date that was.
Sometime on or about August 23rd of 1989, did you have a conversation with Eric Menendez?
Yes, I did.
And what was the nature of that conversation?
Objection, I'm not the.
What was the date?
August 23rd, 1989.
We have the foundation as to whether Lyle Menendez is present. He's not.
Okay, let's have you approach here and we'll discuss it briefly. All right, let's resume with the redirect examination.
Dr. Oziel, we were talking about the Bel Air Hotel. And when it was that you first had contact with Eric Menendez after the killings of his parents. Do your records, Exhibit 97, indicate that you saw the defendants, both defendants in this case, on August 23rd, 1989?
Yes, I do.
Now, you were asked in cross-examination why it was that you went to the Bel Air Hotel. Is that correct?
That's correct.
And you were attempting to answer that question and you were stopped. So I'm going to ask you the question.
All right, let's not review rather the testimony. Just ask the question rather than going back on what did or did not happen during the cross-examination.
Very well, Your Honor. Why is it that you went to the Bel Air Hotel?
Eric and Lyle had requested that I come to the Bel Air Hotel to be with them from a professional standpoint, to counsel them and help them out with anything that arose that was emotionally difficult. But the reason specifically I was asked to go to the Bel Air Hotel as opposed to seeing them in my office is because I was told that the mafia might have a contract on Eric and Lyle, and for their safety, it had to be absolutely secret where they were staying, and there was a lot of security about it, and that they couldn't emerge from the Bel Air Hotel to see me in session.
Who is it that gave you that information about the mafia?
You know, I saw Eric and Lyle the day before, and I don't remember whether it was Eric or Lyle, but I definitely and distinctly remember the content.
It was one of the brothers?
It was one or both of the brothers, but I could not state certainly which it was.
Now, you were asked if you had gone to the memorial services for Mr. and Mrs. Menendez. Did you attend the services?
Yes, I did.
Did you charge the brothers for your attendance at those services?
No, I did not.
And so the charges that were made when you visited the brothers at the Bel Air Hotel was for sessions that you conducted there?
Consultation before or after the services, not for the services.
Now, you've testified that a day or two before you actually saw Eric Menendez on October 31st, 1989, that you received a call from Eric Menendez?
That's correct.
And would you describe for the jurors the nature of that call?
The nature of the call was that Eric called me seeming very distressed and said he needed to see me for an extended session, that it was really important that he see me as soon as possible. He told me that he wanted to be absolutely certain that he was the last patient of the day, that there was basically an open-ended amount of time to see him so that he could stay as long as he needed, and that there'd be no other patients present while he was there. And I don't recall, he may have indicated he wanted to go for a walk at some time during the session or wanted to leave the session at some point. That was the conversations I recall it.
And did you schedule him or see to it that he was scheduled for a late appointment on that day?
I did schedule him for the last appointment of that day, did schedule him such that no other patients would be present, and did schedule it open-ended so that I had as much time as possible or as he needed for me to talk with him.
Now, referring to the sessions of October 31st, 1989 and November 2nd, 1989, in which Eric Menendez confessed, and those sessions in which you were threatened, you were asked whether you kept notes at the time that those sessions were occurring, and you indicated that you had not.
Overruled.
Is that correct? You did not take notes during those sessions?
No, I did not take notes during those sessions.
Was there a reason why you didn't take notes while they were confessing and threatening you?
Yes, there was.
Why?
I'm going to object to the form of the questions and statements.
Objection overruled.
I didn't take notes because I was completely preoccupied with the threat, the trauma, and trying to determine how to cope with the situation that was confronting me.
And you dictated notes about a week later after the November 2nd.
Objection, reading.
Sustained.
When was it that you dictated these notes?
Between a week and 2 weeks. I can't be certain exactly which day it was, near the time, if not the time, that I purchased the shotguns.
And you've been testifying with the aid of a 20-page transcript of your verbal notes from that tape?
That's correct.
Now, you were asked in cross-examination about confidentiality, and you were asked why you told the secrets of the brothers. Now, a question that I have for you is it your understanding that, generally speaking, what a patient tells a psychotherapist is privileged under the California Evidence Code 1012?
Yes, that is my understanding.
Now, would it be fair to say that this privilege, however, is not absolute?
Objection, Your Honor, this is the argument of the witnesses.
All right, the objection is overruled, but if you can refrain from leading the witness.
Is it your understanding that there are exceptions to the privilege?
Yes, it is my understanding there are exceptions to the privilege, a number of them.
Do you know how many exceptions there are to this privilege?
I don't recall the exact number. I don't know if it's 11 or 12, but the most common ones that are used in psychotherapy there are about 4 of them, I guess, that are commonly used.
In particular, the exception that you saw applying in this case was which exception?
Well, the dangerous patient exception.
And what do you know what the evidence code section is for that?
I think that it basically states that in the event that.
No, the question was as to the
Oh.
actual code section number. Is that what you're asking?
Evidence
Yes,
code 1024, is that?
And
Yes.
as a psychotherapist, you're familiar with that section.
Objection leading.
Overruled.
Yes, I am familiar with the section.
And what is your understanding of that section?
With respect to the dangerous patient exception?
Yes.
Yes, that in the event that a patient is deemed to be dangerous to himself or to others, that there is no confidentiality or privilege. That's the understanding that I have.
Now, after the initial threats in the session with the defendants on October 31st, 1989, would you recount for the jurors what it is you did after the defendants left?
And can you be more specific, counsel?
Did you take measures to protect anyone, including yourself and others?
Yes, I did.
What did you do?
Well, aside from what I've already testified to, namely warning people I thought were in danger, I also tried to arrange for my wife and family to be located somewhere where they would be out of the zone of danger. I tried to arrange for myself and for Ms. Smith to be out of the zone of danger. I took security precautions around our house, having the security system fixed. I added new security in the form of shatter detectors for the glass in the back of our residence, which we had not previously had installed. I bought, with my wife, 3 shotguns. In addition to that, we hired an armed guard response unit for our home, and several policemen. We called several policemen at some point and just asked them what general protections you could take. They had disclosed things such as, not having people follow behind you and tailgate you and so on and so forth. So I called up and found out what measures you could take if you thought that there was any danger involved with you. So I did that as well. And those are pretty much some of the precautions that I took, make sure I was out of town for some significant part of time when I thought that I was in danger, threatened. There were a lot of I called a number of people and asked them for advice. A lot of different things that I did.
Now, with respect to immediately after the defendants had left, after the threats were made, and after you learned of the confession, you indicated that you called certain people, correct?
That's correct.
And one you indicated was a Dr. Lulow.
That's correct.
Yeah. Dr. Lulow is also a psychotherapist,
Yes, he is.
psychologist. And did you get certain advice from Dr. Lulow?
Yes, I did.
And had you known Dr. Lulow from previous contacts with Dr. Lulow?
Yes, I had.
When were those contacts that you had with him?
I think they were 1986. I can't remember exactly the date.
The defense in cross-examination asked you whether you had been on probation, and you indicated that you had, correct?
That's correct.
Was Dr. Lulow your supervisor for part of the time that you were on probation?
Yes, he was.
Now, would you describe for the jurors why it was that you were on probation?
Yes, I will. In approximately 1981, I believe, a patient that I was treating initially had the funds to be in therapy and was paying my fee in full. At some point during the therapy, he lost his job and he no longer had any money to afford therapy. And I told him that I wouldn't charge him anything for the therapy since he couldn't afford to come in for therapy. And I continued to see him for some period of time, and he was quite significantly depressed in my clinical judgment. At some point in the therapy, as he became more depressed, he told me that he was uncomfortable not paying me anything for the therapy because he knew that my fee was a significant fee, and he had begun by paying me the fee, and it was not our original agreement that he not pay me a fee, and he felt obligated and uncomfortable and just like it was a big burden. At that point, I suggested that maybe he would want to be referred to another psychotherapist, which I thought would be appropriate if he was having those kinds of feelings. He said, no, he couldn't go through all of this again with someone else. He already had formed a close relationship with me and had already gone through all these things and reached a particular point, and he was too depressed. He just didn't have the energy to continue to start all over again with another therapist. And I told him I was quite concerned that if he didn't get therapy, potentially he could be suicidal, and that I was concerned for his welfare. And he suggested to me that the only way he would feel comfortable continuing to see me in therapy at all was if, in fact, I allowed him to do something, since he had no money, to feel like he was in some way paying something for the therapy that he was receiving. It was his suggestion that he do some handyman work around the house so that he would feel like he was at least paying something for his therapy. And I agreed that in order to have him continue in therapy and continue to receive treatment, I agreed to have him perform some handyman work around the house, which was, in terms of the value of the work, it was a tiny fraction of what my fee was. So there was definitely no attempt to exploit him at all. I was just trying to help him. But the bottom line is that he did perform some work. I was not supervising him or involved with the work. And at some point, he later saw another therapist who, upon hearing that that took place, concluded that it was a technical infraction in relationship to the ethical code for psychologists, made a complaint with the board. I stipulated that, in fact, that was a technical violation with the board, although I made it quite clear that I was attempting to help the patient. It was because I feared that he might be suicidal or not receive any help if I didn't engage in that agreement. The board so stipulated that, in fact, I was trying to help the patient, not harm him, that it was a technical violation of the ethical code. And that is, in fact, that's the probation and that's the event. And that was, I guess, about 12 years ago. And that's the only.
Now, what period of probation was imposed?
I think there's a standard period of probation, which is 5 years for any, if you're ever put on probation, it's 5 years.
What period of time did that cover?
Well, let's see. The event occurred in 1981. I don't think that the probation occurred until 1985 or 6 or something like that. It took a very long time for them to.
Now, when did the probation end?
It ended, I don't know if it was last year or a year and a half ago. I don't recall when it ended, but it ended some time ago.
So during the period of time that you saw these defendants, October of 1988 through about February of 90, you were on probation.
I was on probation, yes.
Now, the defense asked you in cross-examination whether you disclosed your being on probation to all your patients during that period of time. Is there any requirement that you advise the patients that you're on probation?
Absolutely not.
Okay.
No requirement whatsoever to advise anybody that you're on probation.
Now, after talking to Dr. Lulow and getting advice from Dr. Lulow, you indicated that you had tried to reach your attorney, Brad Brunon, but you weren't sure whether or not you had contacted him. Is that correct?
That's correct.
At some point, you did contact him.
Yes, I did.
And do you recall approximately how much later, if not that night?
Could have been that night. Definitely would have been either that night or within a day, I would guess.
Did you disclose to your attorney that you had been threatened?
Yes, I did.
And did you disclose to your attorney that patients had confessed to murders to you?
Yes, I did.
Did Brad Brunon, your attorney, give you any advice on what to do at that point?
Yes, he gave me some elaborate advice.
What did he tell you?
Objection, yes.
Overall.
Well, first he told me that he was scared to death by what I had just told him. He said he was really frightened. He told me that he was a criminal law attorney and
Jack, Your Honor, I'm going to object to this.
All right, the question was advice. What advice? was
what
given?
advice did he give me?
Move to strike the previous sentence.
That portion of the answer will be stricken. Let's start over again. The question was, what advice was given to you?
Thank you, Your Honor. The advice given to me was that he couldn't be sure what to advise me because he said the situation that I described seemed like a no-win situation and a no way to be safe situation.
Let me ask you this, Dr. Oziel.
Yes.
Did you give your attorney,
To strike that, it's not responsive to the question of what advice.
Overall, the answer will stand.
Dr. Oziel, did you give your attorney, Mr. Brunon, some information, some particulars about the nature of the statements that were made to you?
Yes, I did.
What did you indicate to him?
Objection, hearsay.
Overruled.
I indicated to him that there were
At this point, we would assert the privilege. He has no right to give us.
Counsel, do you want to argue the matter?
Yes.
Okay, you may come up here and we can have a discussion. Or better than that, ladies and gentlemen, it's about 2 minutes to the hour, so let's let you get on your way for lunch and come back at 1:30. Don't discuss this case with anyone or form any final opinions about it. We'll see both juries back here at 1:30. The jurors have now left, and the question had to do with what you told Mr. Brunon. Let me ask the witness, whatever it is that you told Mr. Brunon, was it in relationship to what had been told to you in the session of October 31st by the two defendants?
To the best of my recollection, Your Honor, I didn't identify the two.
I understand that, but whatever you told Mr. Brunon, did it relate to what had been told to you on October 31st?
In a general sense.
All right, you did not relate to Mr. Brunon the contents of any sessions you had with the defendants prior to October 31st?
No.
Okay. And what is the defense objection?
Well, the defense objection is that there was no court has previously ruled, and I don't believe this court has adequate information to rule that Dr. Oziel's disclosures to Mr. Brunon are somehow part of the dangerous patient exception or allowable under that. And so we're objecting to any information, to eliciting any information he may have given Mr. Brunon. That may have been a privileged relationship between him and Mr. Brunon, and he may choose to waive that privilege as he has by testifying. But we are not waiving the privilege, and short of a showing of necessity and that a person is within the potential for harm, the Supreme Court has ruled that the privilege is not waived.
Somehow your argument is that he can testify here in open court before the whole world about what he says your clients told him on October 31st, but he can't testify to what he told Mr. Brunon that day about that conversation.
The reason being, Your Honor, very simply, is that it's not at all clear from his testimony what our clients told him. Virtually every time he's called upon to testify about it, facts and details change. He has said the notes are not total, that there are other things. I don't know what those other things are. They simply emerge from time to time. And therefore, I don't know what he would be likely to say. It may contain information that has not yet been revealed before the world, but it certainly would be information that the Supreme Court was not in a position to rule on because this issue was never presented to them.
Well, it is this court's view that the entirety of the October 31st session has been resolved by the Supreme Court in a fashion that it is not privileged, and the witness, his disclosure here in court about the contents or his disclosure to others is not privileged, and this is an area that was dealt with extensively in cross-examination as to what this witness told others, whether it be Ms. Smith, Mr. Brunon, Dr. Lulow, or others. The first mention of Mr. Brunon, as I recall it, was in the cross-examination of August the 5th, your cross-examination of the witness, and reference to the fact that the witness told Mr. Brunon about the confession. So this is certainly an area of proper redirect examination, and I find this area is not covered by the patient-therapist privilege.
I would also like to articulate for the record not only an objection to Mr. Kuriyama eliciting from Dr. Oziel Mr. Brunon's fear, but on the assumption that Mr. Kuriyama knew that that was what Dr. Oziel would testify to, I would cite him for misconduct.
All right, that is noted, and the request to assign misconduct to the prosecution and find error in the question is noted and denied. The objection was made, the objection was sustained. We don't know what the answer would be. It's at this point irrelevant what the answer would be. The answer has been stricken. The issue is what it was this witness told Mr. Brunon and the advice that Mr. Brunon gave to him. Again, not received for the truth of the matter asserted, but to show this witness's state of mind at that point, and also as far as whatever this witness told Mr. Brunon as prior consistent statements of what his testimony is here. if indeed it is consistent with what his testimony is here and is offered by the prosecution after the witness's credibility has been attacked during cross-examination. So it's proper redirect examination. All right, anything else?
I just want to clarify one thing, which is we have been proceeding on the assumption in front of both juries that we are joining in the objections of the co-defendant unless we say otherwise. Is that agreeable with the court?
Yes. However, there have been certain objections made by one defendant that relate only to one defendant. So the record might be a little ambiguous in that regard. So if there is a doubt about that, it should be made known to the court at the time those objections are made.
For instance, these objections, we of course join in, I think, if the context is unclear, we'll clear it up.
Okay, certainly. Okay, we'll be in recess until 1:30. In the trial, the defendants are both in court with their attorneys. The people are represented and both jury panels are present. And we will continue with the examination of the witness. Dr. Oziel, if you get back up here, please. All right, remind you, you're still under oath and you may continue your redirect examination, Mr.
Thank you, Your Honor. Dr. Oziel, I believe we're at the point where you were discussing what the brothers had told you to your attorney, Brad Brunon, on the night of October 31st, 1989. Recall that?
You say what the brothers had told me. I was relaying the conversation to Mr. Brunon. Is that what? Could you
Yes.
repeat the question?
Question is, what did you tell Brad Brunon when you called him after the session that you had with the defendants, in this case, on October 31st of 1989?
I believe that I told him that that I had a patient or patients who had committed a murder, that there had been a number of threats to me in the session, that I was, to the best of my knowledge, the only person who knew of the commission of the murder, and that the threats were related to the fact that now that I knew that there was basically no way that that the people who committed the murder could feel safe as long as I was alive, that was the thrust of what I felt was communicated to me. And I told him I felt I was imminently under threat of being killed, and I didn't know what to do in terms of options. And he then asked me, as I recall, whether there was other evidence that related to the commission of the crime. And I said no. As a matter of fact, the specific statements made to me is that there was no other evidence as to the commission of the crime. That I went through the information about there being no fingerprints. Well, the fingerprints being theirs, but they lived in the house. That the weapons were removed. There were no casings. No one apparently had heard anything. No one apparently had seen anything. And what was relayed to me is that at this particular point, with the exception of my knowledge of it, and also that the people were not under suspicion at all, with the exception of my knowledge of it, that there would be no evidence linking them. And he, I think, began discussing how that was a very scary scenario. That was very frightening.
Did you indicate to Mr. Brunon that the brothers had used false identification in the purchase of the shotguns?
Yeah, I don't remember if I relayed that information or if I didn't, but I did tell him that the weapons were not in evidence, and they probably weren't going to be found. And he just said that that's very frightening. And I said something like, I'm really trying to, I want to help them if I could help them and continue to act as a therapist. On the other hand, I'm really afraid that I and other people might be killed, and I'm not sure what to do. And so I'm coming to you for advice. And his response was that it was like almost an impossible situation. He said that if in fact I went to the police and turned them in, with his experience as a criminal law attorney, that based upon the evidence that I said was existent, that it was at best the flip of a coin whether they would ever be convicted. And he didn't even know how long they'd be held if, in fact, that there was no evidence other than my saying that they said this to me. And he said, with the people that you've described, if you turn them in and they get let out, he said, I'm certainly not willing to advise you to do that because there's an unacceptably high risk that you'll be killed. And he said, on the other hand, he said, if you try to continue treating them, he said, I can't warrant that you won't be killed either. And he said, in addition to that, he said, I can't even suggest to you that you join or become a part of the witness protection program. And the reason for that is, he said, the witness protection program is something where you have a whole new identity, and maybe you'd move to another city, no one would know who you were, where you were. He said, it's just not something that's even viable. It's not even something you could do. You have a lot of ties to this community. You're professional in the community, so on and so forth. I mean, it's just not viable at all. And he said, on top of all that, a lot of people in the witness protection program get killed. He says it's a little known fact that many people in the witness protection program, in fact, are killed. So he said, I don't really know what to advise you. Really, what I need to tell you is that, I don't see a real good choice. I don't see a real good set of options for you under these circumstances. He said, I'm not comfortable under the circumstances advising you to do one thing or another. You have to use your best judgment.
You had to make a lot of quick decisions that night, I take it.
Yes, I would say so. I would say that within about 10 minutes, I had to make all the things that we're talking about or have been talking about over all this time. I really just had from the end of the session to 10 or 15 minutes afterwards to try to assimilate everything that had happened and to try to make decisions about what to do to try and act to protect people who were potentially going to be harmed, and also to try to protect my patients and not go to the police if in fact there was a way to try to lessen the threat such that I didn't have to go to the police.
Do you know where Brad Brunon's office was on October 31st, 1989?
To the best of my belief, it was in Santa Monica, but I don't recall he's moved one or two times.
Now, do you recall the exact sequence of the calls? You indicated that a call was made to Dr. Lulow, a call was made to your attorney, Brad Brunon. You also indicated in cross-examination, I believe, that you called your wife.
That's correct.
Do you remember the sequence of the calls?
No, I really don't remember the sequence.
With respect to the call to your wife, you indicated when counsel for the defense brought up some phone records that there appeared not to have been a notation or a record of a call from your office to your home at that time, I believe, if I'm right, is Sherman Oaks?
That's correct.
You indicated, or is that a toll call from your business phone?
No, it is not a toll call, to the best of my knowledge.
In fact, you checked the records that were presented to you by defense counsel, and you reviewed those records, and there wasn't one call to your residence. Is that correct? Those records?
No, there wasn't, despite the fact that I called my residence from my office, anywhere from several times a day to 20 times a day.
Okay, so Beverly Hills to Sherman Oaks.
That's correct.
Now, at some point, you did reach your wife, correct?
That's correct.
And you told her to leave the house with your children?
I did.
And sometime later, you went to your girlfriend's house, Judalon Smyth.
That's correct.
Would you describe what you did after making the calls that you made that night, and describe for the jurors what you did when you exited your office?
Well, when I exited the office, best of my recollection, I think I went down and asked for a security guard to escort me to my car, as I recall. And then what I did is, after I got in the car, I backed out and drove around and saw whether, in fact, the Jeep was still there, parked there. And it was not parked there. And at that point, I recall having driven to Judalon Smyth's house.
As you were driving, did you ever check in your rearview mirror to see if they were following you or anything like that?
The best of my recollection, I did a couple of times check in my rearview mirror. Pretty much had the belief at that moment that they were not following me to her house.
About how far was Judalon Smyth's residence from where you were in Beverly Hills?
Only about 10 minutes.
Now, that night when you got to Judalon Smith's home, did you then warn her about what the brothers had told you and how they had threatened you?
Yes, actually, I disclosed.
I'm gonna object to the use of the word they. There's been no testimony that we're going to.
Objection overruled. The answer is yes. Your next question.
Yes.
And what warning did you give to Judalon Smith, if you recall?
The best of my recollection, since she had no knowledge at all about the situation, I described the situation of two patients of mine having murdered their parents, and that I felt that that I was imminently at risk, and I also thought that she was at risk, and that my wife and children were at risk, and that I thought that they, if they hadn't followed me, that they could detect our relationship. And I, offered to her at that time and suggested at that time that maybe she would want to be apart from me, or that, if she felt safer, she could choose to be with me, whatever she wanted to do. I also told her some of the details of the sequencing, and including the fact that Eric had come in first, that Lyle had come in second. Told her that afterwards I had made some calls to the police and to Dr. Lulow, so on and so forth, and that I then had gone down and gotten escorted to the car, and that that's what had happened. And I told her something about the nature of the kind of issues that involved the commission of the murder to begin with, and I also characterized something about how dangerous I thought the clients or my patients might be, and the nature of the crime that was committed, so that she'd be able to accurately assess the amount of danger that she was in order to be able to protect herself and know what kind of action she needed to take.
Now, in cross-examination, you testified that you believe that the defendants could come to your house because you indicated that Eric Menendez knew where you lived, correct?
That's correct.
After you had asked your wife and children to leave your house, you indicated that there was a chance of the defendants breaking into your house. Is that correct?
I was very concerned, because they knew where I lived, that they might break into my house that night, number one, to attempt to kill me, and number two, to try to look for any information that related to any other people who might have access to information about them. So for both reasons, I was concerned about them breaking into my house.
And you had indicated that there were some records of business transactions or potential transactions that you would have with Judalon Smith in your home. Some plans, I
That's correct.
Judalon Smith had some kind of a sound and light business, is that correct?
Yes, she did.
And when is it that she first contacted you?
I think it was in June of 1989.
And was it a business offer that she related to you in that first conversation that you had with her?
Well, I'm gonna object to leading.
Objection is sustained.
What was your first contact with Judalon Smith?
The first contact with Judalon Smith was simply her calling and asking me about whether I had any tapes. She mentioned something about a tape called Through the Briar Patch or something, and asked whether I had any tapes in relationship to phobias, that she was planning to put out a line of tape recordings on psychological topics, educational things of that nature. And she was particularly interested in phobias and the treatment of phobias. And I told her I didn't know anything about that tape, hadn't heard of it. And then she asked me whether that was my specialty. And I said, yes, it was. And she said, well, have you ever done any teaching or lecturing or anything that would give you any authority in that field to do some tapes in that area? And I said, yes. So she basically proposed that we, number one, ought to get together to talk about the possibility of doing a line of tapes, with her being the person who did all the tape production and duplication and marketing, and me being the person who put the tapes together. At the same time, she also suggested that and told me that she was in the tape duplication business, and that in the event I ever needed any tapes duplicated, she asked me if that could come up. I said, yes, didn't come up often, but it could come up, that she was in that business. And she also worked with strict confidentiality. She said that she had worked for the FBI, and I believe she said the DA's office before, dealing with highly sensitive material, and that she was used to dealing with very confidential material, and she could be relied on to keep it. And then she said she was going to send me a tape or book, I'm not sure what she said, in the next couple of days, and she wanted to get my reaction after I listened to it. And could I call her back and let her know what my reaction was?
Okay, before we get to that, you had testified that you don't recall Judalon Smyth being at your office on October 31st, 1989. Is that correct?
That's correct.
But you testified that you remember her being at your office on November 2nd, 1989.
Yes, she did come against my my instructions to her.
So this November 2nd, 1989 was after you had warned her about the danger of the defendants.
Yes. At some point, she brought a gun in, I think. I don't know when that was.
Now, are you aware that Judalon Smyth claims to have actually heard the brothers confess and threaten to kill you?
Objection, Your Honor, it's hearsay.
Are you offering this for the truth?
No.
Objection overruled.
I'm
As
aware.
far as the question is concerned, are you aware of that?
Yes, apologize, Your Honor. Yes, I am aware of it.
Do you know whether on November 2nd, 1989, whether she actually heard anything that the brothers said that day to you?
No, I don't. It would be the best of my belief that unless something very unusual happened, that she couldn't have heard, because from the waiting room, I don't believe it's possible to hear anything that someone's saying in my inner consultation office. But I don't, the answer is, I don't know. I can't be certain.
Okay. Now, you indicated that Judalon Smyth called you about her tape duplication business and offered some of her services in that regard.
That's correct.
Did she mention to you any other people that were involved in these kinds of tapes, kind of self-help tapes?
Yes, she talked about neuro-linguistic programming and I guess, I think she mentioned Tony Robbins and.
Now, Tony Robbins is the guy that's on TV with Fran
Your Honor, I'm
Tarkenton.
gonna object to this as involved.
Overruled.
Is it your understanding that this Tony Robbins, who's on TV and he pushes his tapes, is always on TV with Fran Tarkenton? Is that the person that you understood her to be talking about?
I don't know anything about Fran Tarkenton except that he played football, but yes, I know who Tony Robbins is. I mean, I know him from TV.
So she wanted to get into this business relationship with you.
That's correct.
And in fact, according to your CV, you have written textbooks in your field, or a textbook in your field, psychology.
That's correct. I have written textbook.
And you've written articles in psychology.
Yes, I have.
Your Honor, I object to relevance to this unless it's shown that she had a CV.
Objection overruled.
Now, Dr. Oziel, the defense in cross-examination has asked you whether you were obsessed with Judalon Smyth, and you stated that you were not obsessed with her, but rather she was obsessed with you. Is that correct?
That is correct.
Now, you indicated that you met Judalon Smyth first. The first contact was that she had contacted you about this business relationship or potential business relationship. Is that right?
That's correct.
And sometime after this June 1989 initial contact with you, did she send you a letter?
Yes, she did.
Your Honor, I have a 14-page collection of documents stapled. They have them marked as Exhibit 120.
Exhibit 120.
May I approach the witness?
Yes.
Dr. Oziel, I'm showing you what's been marked as Exhibit 120. Take a look at the first page. Do you recognize what's on that page, sir?
Yes, I do.
And what is it?
Well, it's a business solicitation letter asking me to.
Your Honor, I'd object to the witness characterizing it. You can read the letter.
Well, objection is sustained in that it goes beyond the question. The answer is non-responsive. The witness said, yes, he is acquainted with the letter.
And do you recall receiving this letter, Dr. Oziel?
Yes, I do.
And do you recognize the writing, the handwritten message on the first page?
Yes, I do.
Whose writing is that?
It's belongs to Judalon Smyth.
And it appears to be dated June 15th, 1989,
That's correct.
with Judalon Smith's business card.
That's correct.
Would you read for the jury what it says?
Yes, it says, "Hi, Jerry. Thank you for your time and consideration. Enclosed is my poetry book as a token. If you don't have your own tape line, you should. And since that is my business, perhaps I could be of some help to you or the center. So please file my business card for future use. Thanks again. All my best, Judalon."
Going to the next page. Is the date of that page August 11th, 1989?
Yes, it is.
And do you recognize the writing on that document?
Yes, I do.
And who is that document from?
Judalon Smyth.
Now, is that letter, in that letter, does that indicate to you her feelings about you?
Yes, it does.
In which she says, "You feel so good," and thanking you for not running in the other direction. Is that correct?
That's correct.
Okay, and going to the next letter within this exhibit. You recognize the writing on that letter?
Yes, I do.
And whose writing is that?
It's Judalon Smith's.
Now, there appears to be a date, 989. Who placed that date there?
I did.
And when did you place that date there?
I don't recall. I think it was just logging the, so I took these out of envelopes, just logging the time that they came in. But I don't recall the exact time I put the date there.
All the other writing is Judalon Smith's writing?
It is.
And you first met Judalon Smith in June of 1989?
That's correct.
Now, with respect to this page, does this letter indicate to you her sentiments about you? In particular, the seed of our love was there long before we met. It's part of life's plan, destiny. I, for one, have been saving up a lot of water, lots of food, lots of love, and I want to nurture this to full bloom. Is that her sentiments to you in that letter?
Yes, it is.
And with respect to the next letter, also dated 1089, and is that also your date up
Yes,
at the upper right-hand corner?
That's correct. I wrote that.
And does Judalon Smith, and do you recognize the writing again?
Yes, I do.
Is that Judalon Smith's writing?
It is.
And does this letter indicate to you that she wants to give you hugs in person rather than phone hugs? She wanted to come to the office to give you hugs, but you didn't want her to. She talks of business things, and she wished you could just come home to her every night and make the magic happen when you're together. Is that right?
That's correct.
Are these some of the indications to you that she felt obsessed with you as you testified?
Among many others, yes.
Okay, is this just a sampling of the letters that you received from Judalon Smith?
It's a very small sampling, yes.
Okay, the next page, also dated 1089, is that your date?
Yes, it is.
Is that a letter which indicates, "Dearest Jerry," wherein Judalon Smith expresses her desire not to place limits on the relationship? She just wants to love you to the fullest each day and be loved by you. And quote, "Why do you push my panic button by saying things that are limit-oriented? I'm trying not to drive you crazy. I love you. Do you know how wonderful and thoughtful and fun and loving and special you are?" Do you remember getting that letter from Judalon Smith?
Yes, I do.
And with respect to the next letter, dated Monday, October 16th, 1989, it's a 3-page letter.
Yes.
Actually, I'm sorry, a 2-page letter.
2-page letter, yes.
Do you remember seeing this letter
Yes,
on or about October 16th?
Yes, I saw it in person.
And with respect to all the writing on this 2-page letter, is that Judalon Smith's writing,
It is.
except for the upper left-hand corner, which I believe you characterized the note,
Yes, that's true. I wrote those 2 words and the box around them.
and it says suicide note,
It does.
in which Judalon Smith leaves you her 2 kitties? Is that right?
I think she requested that I took care of her 2 cats.
Do you know the names of her cats?
Well, they're listed in the letter here.
Did you know before that, though?
Probably at one point I did, but I'd forgotten.
Shanty and Ishi Kitty?
I believe that's correct.
Okay. Now, the next letter appears to be November of 89. And
Who
Here's-
needs clarification as to whether he's writing the date on this letter?
On which
I'll
one?
ask him that.
The October 89 or
Oh, I'm sorry.
October the 16th, 1989, is that the one?
November 8th.
Oh, okay.
Okay. With respect to the Monday, October 16th, I believe that is her date. Is that correct, Dr. Oziel?
That's correct.
Okay. Now, the next letter appears to be dated 1187 in the upper right-hand corner. Is that your date on the letter?
1187 or 1189?
I'm sorry, 1189.
That's my writing.
Okay. And this is a 3-page letter?
Looks to be, yes.
And did you receive this from Judalon Smyth in November of 1989?
I did.
And is this her writing in this letter?
Yes, it is.
And basically, in this letter, does it say, "You are the kiss of life. I love you. I love being near you. Your love pulsates through me, unlocking doors to rooms no one has ever gone. This is timeless love that occurs and reoccurs from lifetime to lifetime." Was that her sentiments in November?
That's what's contained in the letter, right? Yes.
She writes other letters that contain the same sentiments later in November 25th, 1989. Is that correct?
That's correct.
And without going through all of this, the next 2 letters after November 25th, 1989 are a Valentine's card, February 90. Now, with the exception of the 290 in the upper right-hand corner, is all the writing Judalon Smith on that Valentine's card.
It is.
And I'm not going to get into the substance of the last 2 pages that comprise the last letter, but you have a date, I believe, of 290 in the upper right-hand corner. Is that your writing?
That's my writing.
Everything else is that the printing rather than the handwriting of Judalon Smith.
Are we on the Valentine's Day letter?
No, this is the one right
I'm
after the Valentine's
Oh, I'm
Day.
sorry. Yes, that's true. That's the printing of Judalon Smyth.
Okay, and just basically that last letter indicates, "It makes me sad that I sabotaged the most important, loving, giving, caring, and passionate relationship I've ever known. You're a very generous person to call me 14 hours after I've been a total asshole and tell me good things about me, and you believe in me. I hope I don't let that belief down. I want to make you happy. Love and zillions of kisses, Judalon." Was that another letter that you received from Judalon Smith?
Yes, it is.
Well, sometime after February of 1990, you broke up with Miss Judalon Smith. Is that correct?
Well, I've been trying to break up with her all along, but yes, the final incident was sometime immediately after this.
Are the letters that you've just related, among other letters that apparently you have received, are those some of the reasons why you testified in this court that when asked by the defense whether you were the one that was obsessed with Judalon Smith, that you said, "No, she was obsessed with me"? Is that why you said that?
Objection sustained.
Okay, why is it that you testified that you were not obsessed with her, but rather she was obsessed with you?
Well, these letters and the multitudes of other letters that I have in my possession that she sent me, some of which are a lot more extreme than these letters, are only a small part of the whole picture. She also, in person and in phone conversation, was very continuously trying to push and move the relationship towards something that I told her in the very beginning that it couldn't be and that I didn't want it to be, which is the reason she talked about, why are you always limit setting, and why don't you stop making, I'm trying not to drive you crazy, why do you keep mentioning limits, just let's take things day by day. It's because I was repeatedly telling her that that I didn't want to be in the relationship anymore, and I thought she was getting much too intense and that she was misunderstanding what was happening in the relationship, and I felt I needed to leave the relationship. Each time I told her that, she threatened suicide, and then the one time, the October letter, she actually, I don't know if she set things up or what, but she actually asked me over for a final meeting to give me back the business materials, and when I came in, there was a suicide attempt in progress. So pretty much continued, and that was only several weeks before the 10/31 session that Judalon Smyth had made the suicide attempt. So I was pretty much, after the first couple of months, telling Judalon Smyth that I needed not to be in this relationship, that it was an error, and that she was not taking it at all in the way that I'd intended it for it to be, and there were limits on it. And in addition to that, I just felt that the nature of what she was writing, in not only in these letters but in many other letters, and the nature of what she was saying, she was frequently trying to press me to not be in my marriage and to be with her, and I was repeatedly telling her that that wasn't at all what this was about, so on and so forth. And I just that's the entirety of that is the reason that I felt that she was fixated on me, and she didn't tolerate me breaking up with her.
Now, did Judalon Smyth know that you were married at the time?
Oh, absolutely. She knew from the very beginning that I was married, yeah.
And did your wife, Laurel, know about Judalon?
At some point, yes, she did know about Judalon.
And at some point, because of the danger, she actually came to live with you and your wife. Is that correct?
Because of the danger, because Judalon Smyth stated, number one, she was making some threats.
I'm going to object that the answer is not responsive.
Objection sustained after yes. Everything else is stricken.
Now, at some point, do you recall when you actually broke off the relationship with Judalon Smyth?
Yes, I do.
When was that?
Well, sometime in early March.
Do you recall having a tape played in which you made calls to her house?
Are you referring to the tape that Mr. Burt played that he was using as, I believe, as evidence that I was obsessed with her or something of that nature?
Yes, that
Yes.
evidence. You actually made calls to her residence, is that correct?
Yes, I did make calls to her residence for a specific reason.
What was that?
Well, the reason was I had just basically told her to get out of the house, and knowing her history of having been either suicidal or histrionic, I was concerned. Number one, I was concerned she was going to go to the police, and I was concerned she'd put herself and my family in danger. So that's one concern I had. And the second concern I had was that she might kill herself, and neither one of those was something that I was comfortable with. And so that series of calls that Mr. Burt played were really just completely not representative of what happened in terms of my calling Judalon Smyth at all. They were simply my calling her at that one moment in time when I was concerned she was either going to go to the police or that she was going to commit suicide. And she had left her car outside with her clothing underneath the car in a bag. And that looked very odd indeed. And I was concerned that similar to something she'd done before, that maybe she was inside and she was, attempting to commit suicide or something. That's the reason I made those calls.
Now, when you said that you're afraid that she might take the information to the police, were you still operating under the advice given to you by Brad Brunon back in October of 1989 that just with what you had, it was 50-50 as to whether these defendants would be convicted? Were you going on that advice?
Yes, I was. I still did not know anything about there being any other evidence whatsoever in this matter.
And did you feel at that time that if the police were notified and the brothers became aware that you turned over the tapes, that you would be in danger?
Yes, I did. And yes, I did. I'm sorry.
Now, as you've testified, Judalon Smyth contacted you to offer her services as an audio tape duplicator. In fact, did she duplicate the tapes of the Menendez brothers that were ultimately found in your safety deposit box when the Beverly Hills Police Department served a search warrant on your home and offices on March 8th, 1990?
She did.
She duplicated those tapes.
She did duplicate those tapes in my presence.
Now, focusing back on the defendants in this case, you have indicated that you've made the warnings that you made to your wife and family and to Judalon Smyth, and you've told Dr. Lulow and your attorney Brad Brunon about what information you had. What do you think you accomplished by telling the defendants that you had notes of the sessions with them and that your attorney was instructed to go to the authorities with the notes or tapes if you were to be killed or murdered or mysteriously disappear. What did you think you accomplished by that?
Objection to forming that question.
Sustained.
Okay. What did you think that you had protected yourself in any fashion?
Objection.
What time frame are you talking about?
After you recorded your notes, your audio notes of the sessions with the brothers, and you informed them that you had the notes, what do you think you did to protect yourself?
Objection.
Also mistakes there.
Objection sustained.
Dr. Oziel, why don't you explain to the jurors what you did to protect yourself in getting the tapes that you made or making the tapes of the notes?
Now I'm gonna object and ask for approach.
All right.
Thank you, Your Honor. Dr. Oziel, why did you make those tapes? October 31st and November 2nd.
I made the tapes as a way of, well, I made the tapes for a different reason.
Your Honor, perhaps we should ask.
All right. Why were these tapes recorded by him? You're talking about the tape of October 31st and November 2nd, why he recorded them or why
Yes.
he had them duplicated?
Well, I'll do the recorded first, and then I'll get to the second step.
Now we're talking about October 31st and November the 2nd.
Could you repeat the question?
Why did you record your notes from the October 31st and November 2nd sessions?
For a variety of reasons. Number one, it was important for me to preserve as much detail as was possible to document what had transpired in both of those sessions for therapeutic purposes. It was also very important for me to record what transpired for the purposes of documenting what actions I took from a standpoint of professional responsibility. And third, it was important for me to document what happened and to get the documentation of that into a safe place as a part of a protection or a perceived protection that if in fact there was a follow through in relationship to murdering me, that the entirety of the details of those two sessions would be revealed as a way of trying to disincentive either Lyle or Eric from killing me.
In fact, the police served a search warrant on your house on March 8th, 1990, is that correct?
That's correct.
And were you home at the time that the police served the warrant?
I was not.
Did you get a call from your wife?
I don't recall if I called her or she called me, but we were in contact with each other while I was in the car.
And at some point, did you return to your home and find the Beverly Hills police detectives there?
Yes, I found a number of people there, including Beverly Hills police detectives.
And did you then call your attorney, Brad Brunon?
I did.
At that time, when you saw the police at your house, what was your state of mind with respect to the defendants?
Objection, Your Honor. Wrong.
Could you be more specific as to what you're referring to? Objection sustained.
With respect to the threat, your perceived threat, and the danger that the defendants posed, what was your state of mind on March 8th, 1990?
I believe that the defendants posed a threat. I was concerned about the fact that these notes were being seized, and I was concerned that if they learned that they were being seized, that they might think that I had simply turned them over or betrayed them to the police, which in fact was not at all what happened.
Did you make any requests of any of the officers there serving the warrant regarding protection?
I believe I did ask for some sort of protection.
What sort of protection did you ask for?
Objection, Your Honor.
Overall,
I think I asked for some police protection.
Was Brad Brunon there at that time?
He was.
Now, at some point, did you or Laurel, your wife, accompany the detectives to the safety deposit box in which these tapes were located?
Both my wife and I accompanied the detectives to the safety deposit box location.
And was there a special master, Gary Mogul, there?
There was.
Do you remember whether Detective Zoller was there?
Detective Zoller was there.
Do you recall actually who recovered the actual tapes from the safety deposit box?
My wife did with Mr. Mogul.
After the special master, Gary Mogul, took possession of the tapes, did you become involved in a closed hearing in Santa Monica Superior Court regarding the tapes?
Yes, I did.
Now, there's been a lot of reference to proceedings that occurred in Santa Monica in June and July of 1990. Were you involved and were you a witness in some of those proceedings during that period of time?
I was.
Now, was the privilege issue being litigated in Superior Court at that time?
Objection, Your Honor.
Overruled.
At my instigation, I instructed my attorney, Brad Brunon, to litigate the privilege issue, which was not something I was obligated to do.
Objection, move to strike the answer as non-responsive.
Right. The answer will remain except for the last portion regarding whether he was obligated to do that. That portion is stricken as non-responsive.
Dr. Oziel, you were involved in this litigation, is that fair to say?
That's fair to say.
For the next 2.5 years, did that litigation include the Appellate Court of California, Second District, and also the Supreme Court?
Yes, it did.
Objection, Your Honor.
All right. The objection is sustained. The answer is stricken. Do you want to approach?
Yes.
Okay.
Dr. Oziel, when is it the first time that you spoke to the prosecution in this case about what the defendants had told you? Do you recall?
It was very recent. It was just before my anticipated testimony.
In the grand jury?
Correct.
Do you recall that as being in December of 1992?
I don't recall when it was, but
Now, getting back to the statements of the defendants on October 31st, 1989, in cross-examination, you were asked whether either of the defendants had used the word perfect in describing the murders. Do you recall that?
Mistake, question of
All right. With the understanding that you're not quoting verbatim, the objection is overruled.
Thank you, Your Honor. Do you recall that?
can you
Oziel?
repeat the question, please?
Yes, in cross-examination, do you recall a question being posed whether the brothers on October 31st used the word perfect murder, perfect crime?
Yes, they did.
Have you had an opportunity to review your notes?
Well, I certainly have, on the witness stand, many times reviewed my notes.
And do you recall now, after a review of your notes, whether or not, in fact, they had referred to the perfect crime during that October 31st session?
Your Honor, I'm going to object to the word today.
Objection overruled.
Yes, the word perfect murder was, the phrase perfect murder was used during that session.
In cross-examination, you also testified that at one point, Eric Menendez believed or was frightened that they may get caught on that night. Is that correct?
That is correct.
Is that inconsistent with the language of the perfect crime?
Your Honor, I'm going to object to that calling for conclusion.
Sustained.
Could you describe for the jurors how that information came up from Eric Menendez regarding the situation where he had left some cartridges in the car?
Yes. Prior to the actual commission of the murder, there had been a belief that that the brothers had formed a perfect crime, a plan that would not allow for detection. In the actual commission of the crime, both brothers realized that they had not committed a perfect crime in the sense that the way that it was executed involved leaving cartridges in the car. And since the police could easily have found the cartridges, that clearly was an error. And at the moment that that error occurred, it was no longer in the actual enactment a perfect crime. Once they created a reason for going back out to the car, I believe to retrieve tennis garb or tennis gear or something of that nature, and they were allowed to pick up the cartridges. Eric told me that they again felt that they had now a perfect murder, because to his knowledge that was the only way that he could have been caught that night, best my recollection. And then later, Lyle in the session related to the fact that Eric disclosed to me or confessed to me all of the details of the crime as now returning their situation to one where it was no longer a perfect murder. And the element of it being no longer perfect was the fact that I had a complete confession and had all the information. And at any time, insofar as Lyle was concerned, I could disclose it to anyone. And he related that he did not feel safe at all with that, and that there was no way he could feel safe with that. Even many years from now, I could relate that to somebody else or tip somebody or whatever. And so now I was what was making the murder imperfect. And he was basically alluding to how it was an extremely big problem. And the message I was getting is that he was considering what to do to remove me as a factor, so I no longer could ruin what otherwise would have been a perfect murder.
You're right, but I don't think all of that was responsive. Exactly.
I'm sure you can go back and pick it up. Okay, objection is overruled.
Dr. Oziel, after you established this relationship with the defendants, that they knew that you had these tapes in the safety deposit box, and you continued to see them after that, is that correct?
Yes, I did.
And the sessions up to October 31st are still privileged, correct?
Yes, they are.
Objection, Your Honor.
Sessions after.
Excuse me, counsel. Objection, Your Honor.
Can I have the question read back, please?
Question: in the sessions up to October 31st are still privileged, correct?
All right, there's an objection.
Yes, sir.
Okay, the objection is sustained. The answer is stricken.
After you established this relationship, that you had told the defendants that you had these tapes in your safety deposit box, was there ever a request on either October 31st or November 2nd by either of the brothers in the other brother's presence for you to put down everything and reflect everything in your notes that would somehow explain their motivation for killing their father?
Yes, Lyle in particular had expressed a desire to record or memorialize all of the factors that were motivation related that had to do with the commission of the murder.
And you've reflected those, or you've related those to the jurors based on your notes, those two sessions?
Objection, Megan.
Overruled.
Yes, based upon my notes and my recollection of those two meetings, I have fundamentally communicated the motivation as it was communicated to me.
I have another. It's comprised of 5 pages. Gun records, may I have this marked as exhibit 121, I think?
121. Yes.
Dr. Oziel, I'm showing you what's been marked as exhibit 121. Do you recognize those documents, sir?
Yes, the top document, and yes, the other documents as well. So I'm looking through them. Yes.
Do those appear to be the gun records reflecting your purchase of 3 shotguns on November 6, 1989?
They do.
Was your wife Laurel Oziel with you on that date?
Yes, she was.
Now, looking at the first page of this 5-page document, is that your writing?
No, that's not my writing.
Okay, but it indicates Leon Jerome Oziel as a purchaser?
That's correct.
Is that your signature in the middle section?
That is my signature.
Okay, and with respect to the driver's license, is that your driver's license number?
That is my driver's license number.
And with respect to the Sherman Oaks address, is that your correct address?
That was my correct address at the time.
You moved recently.
That's true.
Now, you bought the shotgun at the Big Five Sporting Goods shop, is that correct?
Yes, that's correct.
Where was that store located?
It was located it was very close to our home,
And what city was the Big Five located in?
Encino.
And you lived at that point in Sherman Oaks?
That's correct.
And with respect to the next page, actually go 2 pages to where Laurel Oziel is listed.
Yes.
Does that appear to be your wife's signature?
Yes, it does.
And the date is also November 6, 1989?
It is.
And does that appear to be her driver's license number?
It does.
Does that accurately reflect your address at that time?
It does.
And going to the last page, actually, the last 2 pages are receipts, is that correct?
Yes, they look to be receipts.
And they're for 2 shotguns.
2 shotguns, yes.
So there was a total of 3 shotguns that were purchased by yourself and your wife?
There were 3.
Now, in your testimony regarding the October 31st and November 2nd sessions, you indicated that you were aware of some abuse by Jose Menendez. Is that correct?
I was aware of a lot of instances or a lot of characteristics that were abusing, yes.
What in particular were you referring to when you testified to abuse by their father? What kind of abuse? Would you relate that to the jurors?
Yes, I think that the,
Your Honor, I think at this point, we probably should be heard at some point.
Is there an objection?
Yes.
All right, you may approach. The juries are not present. All participants are otherwise present. We were discussing the question that had been asked of the witness and the concern expressed by the defense of violation of potential patient-therapist privilege in relationship to sessions that occurred prior to October 31st or even subsequent to October 31st. Counsel have referred to certain portions of the transcript in relationship to the cross-examination. Did you want to be heard?
Has the court looked at 9980 and 9981?
Those were not pages that counsel told me to look at. 9980?
Yeah, 9980 and 9981.
Well, you gave me volume 63 or told me to look at 63, so I need volume 64 apparently. Is that right?
We cited 63.
All right, if we can get volume 64, Penny, from my desk.
What pages of 63 were you referring to? 98, 31.
You said 99, 80, and 81?
Yes, Your Honor.
What are you pointing at?
It begins by Mr. Bird, and is it true that the November 2nd notes begin with your statement, and there's a quote, I further stated that there was some ways in which the session on my part, this information could potentially be helpful. Namely, I related to Eric and Lyle that in the event that they were brought to trial for their parents' murder, that I might be able to piece together some of the events in their family constellation that led to them, led to them having the hatred and abuse, most particularly from their father, that could have led to such an event occurring. And the answer, that's correct, it does state that. So that's a question posed by Mr. Bird in cross-examination, talking about abuse, and I wanted to ask him about that statement.
And what did you intend to ask?
What abuse he was referring to, what the sort of abuse it was.
And what is it that you expect the answer to be?
I expect the answer to be that it was not sexual abuse and it was not physical abuse, it was emotional abuse.
And what is the position of the defense?
Well, we would object to his answer being in the negative. I mean, obviously, our concern is that this quote, 9181, has to do with his piecing together events in their family constellation. Now, I assume that means events with which he was familiar prior to October 31st. Now, if the witness is going to testify based solely on his contact with the parents, fine. But if he's going to testify to illuminate that quote with things he was told by my client, it's privilege.
Well, that's an interesting observation, but why didn't you make that objection at the time Mr. Burt read that?
Well, that's just part of his notes that the court had already ruled was admissible.
Had he already testified about that,
Basically,
using the
yes.
word abuse?
Yes, of course he had.
Had he used the word abuse in his earlier testimony?
Absolutely. Led to them having hatred and abuse. He used it over and over again.
Right, and assuming that is correct, that the prosecution brought that out in direct examination, why then do you feel this opens the door, Mr. Kuriyama, to anything other than what was said, the words that were used in the October 31st meeting?
Well, I think he can testify as to what was not told to him during that period of time. That is,
During October 31st?
yes, in November 2nd.
Yes, he certainly can. He can say that he was never told anything about physical abuse. He was never told anything about sexual abuse.
We object to never unless it's limited to October 31st.
That's what I'm referring to, that in that session, that there was never such mention made.
That's a different question.
Right?
Well, I was saying-
Okay, anything else before we resume?
Mr. Kuriyama said you only has a couple more questions, and I wanted to seek clarification of one point on the redirect, which is Dr. Oziel testified in relation to Ms. Smith that she was pressing him not to be in the marriage, and that he'd been trying to break away from her for a long time. And I again would like to play tape 45 for the jury because it bears directly on his testimony that he was that she was the one who was pressing him not to be in the marriage, when the conversation indicates the two of them strategizing about how they're going to get rid of the wife, and Oziel, not Smith, suggesting that she call up Laurel and say that she was Eric and disguise her voice and threaten to kill her. So I think it is responsive to the redirect. And I think at this point, I would renew my offer and ask the court for permission to play that brief 2-page transcript.
I don't believe that this has opened the area, and it is still something that will require testimony of Ms. Smith, and would put her credibility at issue and all the areas that relate to her credibility. And foundation will have to be laid for when this tape was made and the circumstances for it. So I'm going to maintain the ruling in that regard.
I heard everything on that. He testified now on redirect differently than before. What he said now is throughout the entire course of their relationship, he was resisting and never went along with the scheme of hers, her unrealistic expectation to get out of the marriage. So I don't think it matters any longer when that tape was made. And if he authenticates the voices on that tape, then I don't see what additional foundation is necessary, since time no longer matters. Because he blew it wide open in saying that throughout the entire course of their relationship, she had this unrealistic expectation that he would leave his wife, which he never encouraged. And on that tape, it is very clear that that's his topic of conversation.
All right, certainly if counsel wants to ask him questions that are based upon statements in that tape, whether he said something, you can do that to lay a further foundation for the tape being played at another time, but I am not at this point going to permit that tape to be played. The ruling I've made as far as the order of proof will stand, and that tape, if it does get played, would be played during the testimony of Ms. Smith, since that's in the case they are calling her. All right, so anything else now before we resume? I assume that there will be recross examination after Mr. Kuriyama completes his redirect. And this would be before both juries, before we are in a position to have any further cross-examination only before the Eric Menendez jury. Is that correct?
Yes, sir, and I'm going to yield to Mr. Burt and let him do the cross-examination before both juries in an effort to save time. And I will reserve any cross-examination only for Eric's jury.
All right.
I will, however, pass the notes.
That's certainly appropriate. And the only issue has to do with the fact that you're not reserving any of the material that's being covered here now, just for the Eric Menendez jury. That your cross-examination is truly the cross-examination based upon the direct examination that was completed last week of the witness relating only to Eric Menendez.
Well, with one exception, he has testified about they making threats on October 31st. Now, I intended to go into that on my cross in front of Eric's jury anyway, and I still intend to go into that. I never indicated Eric made any threats whatsoever on October 31st.
All right, well, that was an area that
Right.
was certainly appropriate for the Eric Menendez jury. All right, anything else now before we resume? All right, then let's have both juries out and we will continue the examination. And both juries are back and we'll resume with the examination. Mr. Kuriyama?
Thank you, Your Honor. Dr. Oziel, did either defendant tell you during the sessions of October 31st and November 2nd that they killed their parents due to physical abuse?
No,
Did either defendant ever tell you during the October 31st or November 2nd sessions that they killed their parents due to sexual abuse?
no, they did not.
Did either defendant ever tell you during the October 31st and November 2nd sessions that their parents posed any physical threat to them?
No, they did not.
Did either defendant ever tell you during the October 31st and November 2nd session that they killed their parents in self-defense?
No, they did not.
Thank you. I have nothing further, Your Honor.
Dr. Oziel, both Menendez brothers indicated to you in both sessions that they were suspicious that you were going to not keep the information they were telling to you confidential. Isn't that true?
No, it isn't.
That's not true.
No, it isn't.
And they were not suspicious during either of those two sessions.
That wasn't the question you asked, Mr. Burke.
Were they suspicious that you weren't going to keep the information confidential?
The answer is no. You asked whether they were suspicious. The answer is no.
Maybe I should rephrase it. Did they indicate to you that they were afraid that you were going to leak the information that they were giving you to other people?
The answer again is no.
Did
Overall, the
Did
answer will
Lyle
stand.
Menendez indicate to you at either the October 31st or the November 2nd session that words to the effect of what's going to prevent you from going to the police or other people anonymously?
Yes, he specifically stated that he was fearful that I could and believed that I could anonymously or some other way disclose the information.
And that is something he said to you on October 31st, correct?
It is.
And it was something he said to you in the presence of Eric Menendez, correct?
He did.
All right. Now, I believe you testified on redirect examination that one of the reasons that you recorded the notes was because you thought it was important for you to get documentation in a safe place. Is that one of the reasons you had for recording the notes?
I believe that would be a restatement of what I said.
All right. And is it true that you may not have recorded those notes until March 9th, 1989?
No, that's not true.
Didn't you testify on cross-examination November 9th?
Oh.
Sorry.
November 9th. It's possible that I may not have. I think I said a day or so up to about the point when I purchased the shotguns, which I just see in front of me. The record shows it's November 6th, sometime around November 6th.
All right. So one of the reasons for recording the information was it was important for you to get the documents in a safe place, and yet you may not have recorded those notes until November 9th, 1989, correct?
November 9th, I think, would be the very outside date. I believe they were recorded prior to that, but Yes, I believe that's correct.
And as far as getting the documents in a safe place, if you recorded them on or about November 9th, where is it that you put the documents on or about that date?
In the safe in my house.
And the house was the place that you testified Eric Menendez had been to and knew where you lived, correct?
That's correct.
And as far as you knew, there could have been the ability on their part to come in, break in the house, and get inside your safe, right?
The answer is that was a possibility, but by that time, I did not believe that that was going to occur. That was my fear the first night. I didn't believe at the time of November 9th that it was likely they were going to break into my house and take the tapes.
When did you decide that that likelihood didn't exist?
I couldn't answer that question.
Just roughly.
I'd be speculating totally. I don't recall the exact moment or anything like the exact moment that I decided that. I think that my fear about them imminently killing me that moment was pretty much October 31st. It diminished to some extent November 2nd when we had the conversation about the notes and the tapes and, you know, being in a safety deposit box. And I think after November 2nd, I wasn't as concerned that they were going to break into my house and take things in the house that related to the contents of notes in my house.
So by November 2nd, that fear had diminished? Is that a
By November 2nd, the specific fear that they were going to break into my house and rummage through my house to try to find documents had diminished.
And it was sometime after November 2nd that you went to Newport Beach, is that correct?
I believe so, yes.
It would have been the weekend of November 4th, correct?
That's correct.
And you've already told the jury that the reason you went to Newport Beach was because you feared going back to the house, isn't that true?
That's correct.
And that would have been after this November 2nd date where you say your fear had diminished as to their ability to break into your house, correct?
No, I didn't say my fear diminished as to their ability to break into my house, Mr. Burt.
Your fear had diminished about what?
My fear had diminished in relationship to their motivation being the very night they confessed to me, killing me and trying to rummage through my house at the same time. That was I only had 10 minutes to be thinking of these things since after the session, I had a period of just a few minutes to make decisions. And that was my feeling that first night. By the time I went to Newport Beach, I just wasn't feeling as concerned that that was the action they were going to take.
Well, but somehow you must have been concerned they were going to take some action that involved breaking into your house, correct?
I was by that time, I was much more fearful that they simply would be planning a way to kill me.
Well, you said that you took all these protective measures and you described how you got a security system upgraded, correct?
That's correct.
And that security system wasn't upgraded until November 16th, correct?
That you've stated that, and that may be what some record indicates, but I recall that we took measures before November 16th that may not be reflected in whatever record you have.
And if the police department interviewed your security company and they told them that your system was upgraded on November 16th, would that be false?
No, I'm not saying it would be.
Recollection?
No, I'm just saying we may have taken measures that didn't involve having our security company come out. That's all.
And why were you buying the shotguns on November 6th?
For personal protection.
At your home, correct?
That's correct.
And that was on November 6th.
That's correct.
And so at least by November 6th, you must have still feared that there was some idea they were going to come to your house, correct?
Yes, that's correct.
And so you kept the tapes in your house on or around November 9th, correct?
That's correct.
And when did you finally remove them from the house?
I don't have any recollection of when they were finally removed from the house.
Well,
I wasn't very concerned about the issue of the tape recordings from a standpoint of protection once they were made. Once they were made, Lyle and Eric knew they were made. They weren't protective in relation to being in a safety deposit box or being in my house. It wouldn't have mattered where they were. The point is Lyle and Eric knew they were made, and the fact of their knowing they were made is what was protective, not where they were stored, Mr. Burt.
now, when did you first tell them that you had notes of that session?
First debate, what session?
The
Sustained.
session of October 31st or November 2nd.
May have told Eric something about keeping notes when Eric was there alone on the 31st, told Lyle and Eric about the notes on November 2nd.
And on that date, you also told them that the notes were in a safety deposit box, correct?
That's correct.
And you told them that your attorney had keys to that safe deposit box, correct?
That's correct.
And that was a lie, was it not?
That was a bluff to save my life, yes. If you want to characterize it as a lie, that's fine, Mr. Berg.
Well, you were giving them false information,
It was a
correct?
bluff that was false.
And the motivation for giving them false information at that point was
To save
protect
my,
yourself.
to save my life, yes. That's correct.
In other words, to further what you perceive to be your best interest, you were giving them false information.
My best interest, my family's best interest, other people's best interest, absolutely in relation to trying to save my life, I did proffer false information.
And how long did you keep the tape inside your home?
I don't recall.
Well, what happened to it next? Where did it next go?
I think it next went, well, first of all, I think I continued to record sessions to say,
Objection, Your Honor.
Let's have the question read back, please.
Question, well, what happened to it next? Where did it next go?
Why don't you answer that question? No, you can answer that question.
ultimately, the tape next went to the safety deposit box.
And I think you were shown the safety deposit box indicating that,
Excuse me, correction. I have to correct that. Correct my testimony. I think it went from that location to be duplicated at Smith's duplication facility, just temporarily for me to watch her duplicate it. Then, at some point after that, it went to the safety deposit box.
and when was the tape duplicated by Judalon Smyth?
I don't recall.
And is it true, based on the entry into the safe deposit box, that you first went there on December 7th, 1989, based on your previous testimony?
Yes, I didn't go there. My wife put the tapes in the safety deposit box.
And do you remember being shown the safety deposit box log,
Yes, I did.
and that the first entry after July of 1989 is December 7th of 89?
I don't recall that, but if you're telling me that, I will accept that that's when it was.
All right. And is it your testimony that you were still in fear of the Menendez brothers on that date?
Yes,
In fact, you, according to your testimony just here today, were still in fear of them on March 8th, 1989, correct?
that's correct.
And
A greatly diminished fear, but it was a fear, yes.
well, do you remember around March 8th, 1989, having a conversation with Judalon Smyth?
I'm sure I did, but I don't recall any specific
Do
conversation.
you remember Judalon Smyth saying to you in a conversation on or about March 8th, 1989, 1990, Jerry, if those boys aren't caught, they're always going to be out and they're always going to be a threat. And your answer, Judalon, they're not a threat. They're not a threat. But if you keep stuff about them, you're going to be in the files. You're going to be absolutely documented in the files. Do you remember making that statement to her?
No, I actually don't.
If you made that statement, would that be a false statement on your part?
No, I don't even understand what that statement would mean.
Well,
I don't.
do you remember threatening to put Judalon's name in a file that you had?
The only thing that I'm aware of is, first of all, her name already was, and as far as I was concerned, something that they could have learned about. But I don't remember the context of this conversation at all. It was 4 years ago, and I think she called me multiple times. I don't recall this particular interaction.
Do you remember telling her that Judalon, everybody that I believe in any way might know something about this is going in those files? Remember making that statement to her?
No, I don't. But the only one who knew anything about that was, in fact, Judalon.
I object to the last part of the question, it's not responsive.
Objection sustained. The latter portion of the answer is stricken.
And to remember in that same conversation saying to Judalon Smyth Judalon, what are you going to do with the stuff that you have? Because if you're not going to do anything about it, then you're going to have to go in a file. The first thing I'm going to do tomorrow morning is, if I don't get complete cooperation from you at this point, is create an entire file that documents all the stuff you've done, all the stuff you revealed. And she says, Jerry, this is blackmail. And you say, no, this is not blackmail. And she says, yes, it is. And you say, no, it is not blackmail. And she says, if I don't give you my complete cooperation, you're going to manufacture a file. And you say, no, the file has to do with the people that I suspect. Do you remember making that statement to her?
No, I don't remember making the exact statement, but I know what it refers to, and it doesn't refer to anything that you're alluding to at all.
Your Honor, I object and move to strike the non-responsive part of the answer.
Objection overruled. The answer will stand.
Do you remember telling her that you were going to create an entire file that documents all the stuff you've done, all the stuff you reveal?
Yeah.
Overruled.
I remember telling her I was going to create a file, but not having to do with what you're alluding to at all.
And do you remember that she was tape recording that conversation you had with her?
I didn't know that she was tape recording it, no. Did you want me to explain what it alluded to?
You can do that on redirect.
Okay.
Now, doctor, with all these protective measures you were taking with regard to your house, did you feel at some point that it was safe to go to the police?
No, well, no, I didn't, and I didn't want to go to the police.
You were shown a bunch of letters that Judalon Smyth wrote to you, correct?
That's correct.
And do those letters, in your mind, show that she had certain feelings for you?
Yes, they do.
And do they also, in your mind, conclusively show that you were not obsessed with her?
I don't know that those letters in and of themselves conclusively demonstrate that, but it certainly is true that I was not.
Well, you brought these letters to court, correct?
No, they were requested of me by the district attorney's office.
And was a request to basically bring letters that you thought illustrated the point that she was obsessed with you?
No,
What was the request?
to bring any communications from Judalon Smyth that I could find as quickly as I could gather them together.
And you said you had a lot more of them home, but you didn't bring those. And in fact, there were some better ones than these, correct?
Sustained.
Did you say that you had other letters at home along the same lines as what these letters were in terms of the themes that are illustrated in the letters?
Yes, I did.
Well, was there some reason you didn't bring those letters?
Those were brought. It was the decision of the district attorney's office which letters that they were. First of all, it was the decision of the district attorney's office whether to read any letters at all. Not my decision. I didn't suggest that. And secondly, it was up to them which letters they selected to be read or the fact that they were read at all. I had nothing to do with any of that.
And in your mind, do these letters show, as I asked you before, that Judalon Smyth had certain feelings toward you?
Yep, ask me answer.
Well, on the objection that you've stated, the court will overrule the objection on that ground. She's not going to try again, so
No,
go
I
ahead.
was Doctor, did these letters in your mind show that Judalon Smyth had certain affectionate feelings toward you?
These letters and all the rest of the letters and all of the context of the entire relationship absolutely demonstrated that she had more than affectionate feelings towards me.
And did they also, in your mind, absolutely show that you were not obsessed with her? Did they bear on that issue at all, in your mind?
I don't think that that those letters specifically demonstrate that, but I'm sure that Judalon Smyth has any letters that demonstrate that I was obsessed with her. I'm sure she'll produce them.
Well, again, they don't bear on that question at all, do they? on your obsession?
I don't know that they do. It's not for me to decide these things.
And the letter, one of the letters is the October 89 letter, which Mr. Kuriyama quoted to you in part, correct?
Which letter was that?
The one that you dated 1089. Do you have that there in front of you?
No, well, I might. I think there were two 1089 letters, Mr. Burt.
One that starts 1089, dearest Jerry, and there's some printing. Let's just see how beautiful we can make it grow. You see that one?
Yes, I do.
And he quoted you the end of that, which says, I'm trying not to drive you crazy and to grow emotionally myself, correct?
Yes, you did.
And then he quoted, I love you. Do you know how wonderful and thoughtful and fun and loving and special you are? Do you remember him quoting that to you?
Yes, I do.
He left out a paragraph, didn't he? In between the portion he quoted and the last portion.
Yes, he did.
But read to the jury the part he left out.
There are some days I could just park a well-fed pigeon right over your head, a la Larson.
And do you know what that has reference to?
I can make a wild speculation, Mr. Burt.
And you say during that entire period of time, from the time you met her, basically until the time when the police, when she moved out of your house, you were trying to get away from her, correct?
I don't believe that was my testimony.
Well, was your testimony that you've been trying to break away from her all along? Do you remember saying that?
Yes, all along, if I were to clarify that, I definitely wouldn't say I was trying to break away from her from the first day or first week or first month. What I really meant is after I decided that this was getting out of hand and in relationship to anything that I thought I was ever communicating to her, from that point on, I was trying to find ways to break off the relationship. So I would say that from several months into the relationship through the end of the relationship, I was at different points trying to break off the relationship.
And you also said she was pressing you not to be in your marriage and basically bringing a lot of pressure to bear on you, correct?
Very frequently and very repeatedly.
And you also said, both here today and yesterday in cross-examination, she was fixated on you, correct?
I think that's, I don't know if that was a term that was in the press conference, but yes, I believe that she was extremely attached to me.
And you categorically denied that you were pursuing her in any way, correct?
I don't know that I categorically denied that I had any role at all in there being a relationship. I think that would be an untrue statement, and that's not usually how relationships are formed. What I was testifying to is that I was not pursuing her initially or trying to get a more committed relationship with her in any way. As a matter of fact, I wanted a very limited relationship with her and thought that's what I was communicating. And she tried to take the relationship and bring it into an area or level of commitment or involvement that I absolutely didn't want. That's what I meant to testify to.
And when I was asking you about all those phone calls you made, you were trying to make the point that she was the one who was actually causing you to make those phone calls. Isn't that true?
No, no one caused me to make the phone calls. What I was trying to testify to is very simply the fact that
I object to all the rest is not responsible. I think there was a-
Objection sustained. If you could just confine your objection to the legal basis for your objection. All right, your next question, please.
You were explaining when I asked you about those letters, and excuse me, could I have 1 minute?
Certainly.
I was asking you about the phone records. And your explanation for all those calls, this is at page 10,069, was 64.
What line?
This is line 27 at 10,069. You said, Dr. Oziel, one of the reasons I was making all of these telephone calls, or a lot of them, had to do with Judalon Smyth obsessively calling me and wanting reassurance and trying to elicit me calling her. And in addition, she couldn't call me at my home, so she asked me to call her very frequently. So it was at her request that I made these phone calls. Do you remember that?
If that's what I testified to, I shouldn't have said obsessively calling me, because the fact is that I had an agreement with her not to call me, because she only could have called me at my answering service, where she wouldn't have been able to leave me any message in any event, or at my home, which I specifically instructed her not to call. But other than that, I think the answer is correct.
Well, that's false testimony, because you did tell her to call you at your home. Did you not?
Sustained.
Is that false?
Rephrase the question.
Is it false testimony? Because didn't you in fact tell her to call you at your home?
I don't recall having told her to call me at my home, and I think she called me at my home a total of maybe once or twice throughout the course of the, or several times throughout the course of the relationship. So I don't recall that. I'm not saying it's false or not false. I don't remember it.
Well, do you remember on calling her up and you saying on her telephone answering machine, "Are you there? And I'm just getting ready to leave in about 10 minutes. So if you can call me by 7:10 or something like that, we could talk. Otherwise, we won't catch each other, and you'd have to call me at home." Do you remember making that statement on a tape?
Objection made.
Yes, can you be a little more specific?
Yes, in March. Do you remember that?
Oh, in March. By March, that would have had a completely different meaning altogether, Mr. Burt. That would have had to do with the whole situation of her turning in tapes to the police department by March, and by March she'd already been in my home. So I think that's again a distortion that completely misleads people in relationship to what occurred.
So would it be fair? I don't have objection to that answer. So would it be fair to say?
Wait. We have one objecting, the other not objecting. All right. All right. So the objection is overruled and the answer will stand.
Would it be fair to say that your relationship changed in that regard? In other words, around March, there was more free-flowing communication between the two of you in terms of your ability, her ability to call you at home and your ability to call her back in the presence of your wife.
I would say that would be true.
Okay. And would it also be fair to say that in the early part of the relationship, that is from June of '89 forward, that if you look at that time period, June '89, say to December '89, that she was the one who was being obsessive with you?
Yes, she was being obsessive with me, but I'm not relating to phone calls as any sort of a way of describing obsession at all. I think it's completely misleading.
And I think what you described for the jury on numerous occasions is during the period between June of '89 and December '89, your basic stance was one of trying to get away from this woman.
No, that misstates my testimony.
Well, what is your testimony in that regard?
I believe I just testified that it wasn't from the beginning of the relationship in June that I was trying to get away. I think I said that beginning several months into the relationship, sometime I believe in maybe September, I began telling her that I thought this was not a good idea, that we should never have moved it from a business relationship into a personal relationship, that she was responding much too seriously to it in terms of wanting something out of it that wasn't going to happen. And from that moment on, that's the basic stance that I had with her. And I did try to sever the relationship altogether on numerous occasions. And her typical response to that was to threaten suicide. And on one event, she actually did ask me over for a meeting at a time when she had actually made a suicide attempt or gesture. I don't know which it was, but she definitely was in the process of looking like she was attempting suicide at the time that she called me over to her place.
And when were you attempting to break it off in terms of time period?
I think I just testified to that.
Could you, around September?
Around September, certainly, from sometime in September and October is the time that I recall having.
All right, Mr. Burt?
Doctor, do you have that document in front of you, which is the June letter from Judalon Smyth, the business letter regarding her tape business?
Yes, I do.
And what is the date of that letter?
That letter is dated June 15th, 1989.
And to your mind, was that letter brought up or brought in by you to show that you had a business relationship with her?
No, as I told you, the district attorney's office asked me to bring in whatever documents I had around, so I didn't bring any letter in for any particular purpose. I brought them all into the district attorney's office, and they decided what to do with them, if anything.
Well, that's a letter you released to the press during your press conference in September of 1990. Isn't that true?
Yes, I believe it is.
And what was the purpose of releasing it to the press in September of 1990?
To establish that she had solicited me for business purposes.
And to establish that your relationship was a business one. Is that true?
Was in part a business one, yes.
Well, you represented in that press alert, that media alert in September, that your relationship was strictly professional, did you not?
No, I don't believe I did.
Well, did you represent that you were involved with her romantically?
I don't know or recall what the press release said or press conference said, but I don't recall it having said that I only had a business relationship with her and didn't have any personal relationship with her.
Did you say in your press release in September of 1990, she called me with a straight business proposition to produce a series of behavioral therapy tape cassettes in areas of my expertise?
Mr. Burt, I don't have my press release, so if you could show it to me.
Sure. This is exhibit. Bottom of the page.
Okay. Yes, that's what it says.
All right. And it's true, is it not, that shortly after, and you released that letter to the press, that is the June letter, to prove your point that it was a business relationship?
Well, I think the firm that was representing me released the statement to the press to basically respond to a televised segment that had a number of miscommunications or errors in it. So I think it was a clarification, and this was just one part of the clarification.
And it was the firm that released it. You had no responsibility or involvement in that at all. Is that your testimony?
No, I didn't say that. You simply said I released it, and I did not specifically release it.
What you mentioned the firm as having done that, correct?
That's correct. That doesn't mean I had no responsibility for it.
All right.
Didn't state that.
Did you have some responsibility for releasing that letter?
Sure I did.
By the way, I noticed when you were asked to look at those documents on the firearms transaction, you immediately identified your signature, correct?
Yes, I think I did.
Was there some reason why you had trouble recognizing your signature on the letter you wrote to for Judalon Smyth yesterday when I asked you whether that was your signature?
Yes, there was.
What was the reason?
Didn't look as much like my signature.
Do you still believe it may not be? Or do
No.
you believe it may not be?
I think I already testified to that, Mr. Burt.
And is it true, Dr. Oziel, that beginning around Judalon Smith's birthday that you started sending letters to her?
I may have sent some letters to her.
And that was shortly, do you know what her birthday was?
No, I don't
Date.
recall.
Is it around July 8th?
May have been.
Right. And did you send her a letter around July 8th, 1989,
I may well have.
expressing to her at that time certain feelings that you had for her?
I may have.
And showing you Exhibit 122, and specifically the first page of that exhibit. Do you recognize the handwriting on that letter?
Yes, I do.
Is that your handwriting?
That's my handwriting.
Is that a letter that you sent to Judalon Smyth as a birthday card?
Shall I read it over to determine whether I sent that?
If you could, yes.
Okay. Yes, I sent that.
And that was sent to her on or about July 8th, 89.
That sounds about right.
And you said in the letter in your own handwriting, well, you keep talking about children. You are a new and special friend who feels much, much more familiar than that. I sense your need and ability to care, to be kind, to love. I see you've learned much and are trying to use what you've learned. You are an honest, open, bright, creative, sensitive, and perceptive woman. There's much in you to admire and treasure. Thanks for letting me into your world, and a very happy birthday, Jerry.
That's correct.
And by that time, that is on or about July 8th, 89, had your relationship changed from one of strictly business to something else?
I think that, well, first of all, there certainly was no sexual relationship involved that I can recall at this point at all. I think that, yes, it had. I think that we'd spent a lot of time talking about both business and personal things. She'd shared a lot of feelings with me, and I'd shared a lot of feelings with her. I think I've already testified that for the first several months of the relationship, that we had an involvement, and I think I testified that sometime around September, October, I started wanting to break off that involvement. So this would be very consistent with what I said.
And is the next document in that exhibit also a letter written in your handwriting?
Yes, it is.
Does it say, "Dear Judalon, happy birthday a second time. Just a few things to let you know someone remembered. I wish for you lollipops and roses, real love, peace, freedom from worry, good friends, good health, and all things good on your birthday. You are a survivor, yet you are fragile and delicate. You have strength, yet you are very feminine. You are unique, loving, caring, sensitive, sweet person. Really much too sweet for this world much of the time. You are a part of the universe I've never really experienced before. You are very new for me, and I wish you only love." Signed, Jay.
Yes, there's no date on this. I'm assuming that this relates to some card. I don't know.
Well, it identifies
As
itself
a birthday,
as a second birthday card, right? So you sent her that around July 89.
assuming I wouldn't have sent her one July of 90, yes.
Okay.
That's correct.
Well, did you send her one July 9?
I'm saying, I'm assuming I wouldn't have sent her one July of 90.
And then is it your testimony that your relationship changed after those letters were sent?
No, it's not my testimony that the relationship with her changed immediately after these letters were sent.
Well, sometime around the end of the year, I think you said, was when you were attempting to break it off, right?
Yes, that's correct.
And is there a letter in there dated January 8th, 1990 in your handwriting? January 8th, 1990?
Yes, there is.
You're laughing. Aren't you?
I'm laughing because I know the context of this and what happened, and it's very humorous.
Is this whole proceeding humorous to you?
Mr. Burt, I never said that. I'm laughing at the letter, and you asked me if I was laughing at the letter. My response was no. Or was yes, I am.
Do you realize in this case that the Menendez brothers faced the death penalty?
Of course.
Overall,
Of course I recognize that.
Is there anything funny about this trial itself to you?
Of course there isn't, Mr. Burt.
All right. Is there a letter in your handwriting, January 8th, 1990?
Yes, there is.
And is that a poem which you wrote to Judalon Smyth at a time which you've testified you were trying to break off the relationship?
It wasn't a poem I wrote to Judalon Smyth. Judalon Smyth repeatedly told me that she'd never received a birthday card in the last 3 years from anyone. She said it would be wonderful to receive one. That's why I sent her two. And she also repeatedly told me that no one had ever written her a poem. And I was in her presence. I don't recall if it was her place of work or whatever. And she said, "Why don't you write me a love poem?" And I said, what do you want me to do that for? And she said, I've never had a love poem in my life. I said, well, I really don't write love poems. And she said, well, why don't you make one up? And I said, we had this long conversation about why she wanted me or needed me to write her a love poem. She said, because I've never received one before and I want one. I said, fine, great. I'll write you a love poem here on the spot. And at that point, I took out a pen and literally within a period of about 10 minutes, wrote this out and handed it to her. And that's how she got it. I guarantee you there'll be no letter or stamp or anything associated with this. It was handed to her in her presence within a period of 10 minutes after she requested it.
And you dated that January 8th, 1990, correct?
I suppose I did.
At a time when you say you testified to this jury under oath that you were trying to get away from this woman, correct?
That's correct. My testimony was accurate.
And the last lines of your poem are, for like a nymph, she strides from the forest at daybreak dressed in white, where no other man has truly known her, Judalon.
I can't read all that, but I'll stipulate that probably it says something like that.
Dr. Oziel, you have described your probationary status in 1986, correct?
That's correct.
And you explained to the jury your understanding of the severity and the nature of that particular offense, correct?
That's correct.
And I don't think you explained to him that in fact you had 2 licenses that were revoked. Isn't that true?
Well, there were allied licenses when one was not revoked, Mr. Burke.
So you had a clinical psychology license from the Board of Psychology, did you not?
That's correct.
And you also had a separate license at that time, didn't you?
Yes, I did.
And what was the separate license?
Marriage, family, and child counseling license.
And there were actually 2 proceedings pending against you because different agencies handled those licenses. Is that correct?
No, in reality, what happened is that the marriage, family, and child counseling board simply handed over the proceeding to the psychology board and stipulated that whatever they found the marriage, family, and child counseling board would also accept. So they operate in tandem. If there's a claim with respect to one license, then the other board also automatically becomes involved with the same claim.
But there were parallel proceedings.
Not to my knowledge. To my knowledge, the MFCC board turned over the proceeding to the psychology board. And I never talked with anybody in any significant way with the marriage, family, and child counseling board. They simply referred it over to the psychology board.
And Court Day also sued you in a court of law, did he not?
Yes, he did.
And you had a provision in your insurance contract which provided that your insurance company could not settle a lawsuit without your consent. Isn't that true?
I don't know if that's true or not.
Well, in this case, you were consulted before a settlement was reached, correct?
I don't recall. It was a long time ago, but that might have occurred.
And you ended up paying Court Day some money, didn't you?
No, I didn't end up paying Court Day any money.
You had no personal liability. Your insurance company had to pay off. Isn't that true?
The insurance company made some settlement with Court Day.
So basically, it was no monetary consequence to you
No, it wasn't.
because your insurance company covered it.
That's correct.
And I think you said that your license, neither one of your licenses was suspended, correct?
No, I didn't say that.
Was either license suspended?
I think they were both suspended for the same period of time.
How long was it suspended for?
I don't recall. I think it was 30 days.
And Dr. Schoen, you ran for Schoen.
What do you have there?
Marked as defendants next in order. Exhibit number 123, which is the decision and stipulation from the Board of Psychology.
Are you asking for another exhibit to be marked, Mr. Byrd?
At this point, I'm asking that another exhibit to be marked as 124, which is the stipulation and settlement before the Board of Behavioral Science Examiners, Department of Consumer Affairs, State of California.
I've been discussing the scheduling with council. We have some other matters yet to discuss, and it's now 4:30, so we'll have to continue tomorrow with this witness's testimony, and then I'll discuss further with the attorneys other matters dealing with our schedule. But there's no need to keep you here anymore today, so I'll excuse both juries until tomorrow at 9 o'clock. Don't discuss this matter with anyone or form any final opinions about it, and we'll have both juries back here tomorrow at 9 o'clock. All right, in regards to the scheduling, then let's first ask the defense for a preview of what it is that you expect Ms. McPhee to testify about that's the subject of this hearing, so I have some idea what it is that we'll be going into.
Well, I think maybe the easier way to proceed, Your Honor, is we provided discovery to the prosecution and gave a statement that the witness has made. That would be our offer to its online in that several page.
Well, why would we be having a hearing? What is it then that people object to?
Yeah, I was just informed, I came back from break, that they wanted her on trial. I don't have the discovery with me. We're objecting to her testifying at all about anything happening in the Beverly Hills. But I can't be specific because I wasn't informed until 3:30 this afternoon that they even had her in town or wanted to put her on.
All right, well, I was informed at 4:25.
Okay, well, I'm just saying, I can't.
Okay. What I would then suggest is that if this is the witness that, or who will be the subject of this hearing, the people state a broad objection to anything relating to her proposed testimony, then counsel should submit to me the statement that is the basis of your anticipated evidence that she will produce by way of testimony, and I'll review it. And it might be that there's no need for her testimony, or there is a need for her testimony once I've reviewed it. It would help me, however, if counsel for the prosecution, let me back up. It would help me if the counsel for the defense would be more specific as to what it is that you would intend to offer from her testimony. Looking at this is a document of multiple pages, unnumbered, but it appears to be about 10 pages, single spaced. I assume you're not offering all of that to the jury, so if you could give me an idea more specifically what it is that you will be offering.
Well, we would be offering what's contained in that document.
Every single word.
Well, first of all, Your Honor, the idea of having the defense submit a statement of the witness without an objection, the prosecution's basic position is, well, we object to everything she's going to say. We have never, in this trial so far, had a procedure where the defense can stand up and vaguely allege, we object to everything the witness says, and the court imposing the burden on the person offering the evidence to come forward with chapter.
Oh, no, we had that.
Yeah,
we had that with Dr. Oziel, and we went through every word and phrase in his two tape-recorded statements. That's what I'm asking. Lots of times people are interviewed and they say all sorts of things, such as the conversations of Craig Signorelli that occurred with Eric Menendez, and there was objection to that. And both sides had documents that they went through as to what it was that either side was going to offer. So you're wrong when you say there's no precedent in this trial for that. That has occurred. And the reason I'm asking the question is that when people are interviewed, all sorts of information is obtained that's extraneous to the testimony of the witness. And if I could have some preview of what the witness is going to say in light of a generalized objection by the prosecution, which I can only assume is based on relevancy or something of that nature, I'd have a better idea of being able to deal with that sort of objection.
I guess the court missed my point, which was normally in the situations the court referred to, the defense has made specific objections. For instance, with Oziel it was privilege or 352 or character evidence. And then the court considered those objections in light of the information we had in front of us as to what the witness has said. Here, the prosecution simply says, we object to the witness. There's no basis for an objection other than they just don't want the witness to testify. And we have, pursuant to 115, handed to the prosecution what we intend to elicit from the witness. That is, we would intend to offer what's in that interview. And there is other information that's provided in an interview. And we have tailored the document that we handed over to the prosecution in light of the 115 requirement that we're required to disclose what we intend to offer. I can state to the court that in general, this witness will testify as an impeaching witness of Dr. Oziel to certain things he said. For instance, Dr. Oziel denied having called this witness up and bragging about what a big media star he was. This witness will testify to the contrary, that she had a telephone conversation with Dr. Oziel in which he was bragging about what a big media star he was concerning this case. She will also testify as a character witness and will give her opinion about Dr. Oziel's character trait or lack thereof for honesty or dishonesty. And we would also be offering the specific acts outlined in that interview under People versus Wheeler for impeachment purposes, and also for a separate and distinct purpose, which is to show a pattern, practice, habit, and custom on behalf of Dr. Oziel to use information in his possession, gained from his patients, to manipulate people for his own personal, financial, and sexual needs.
All right, and this is all information contained in the document?
Yes.
Okay, then the people can review the document and indicate to the court whether there is any need whatsoever for a hearing under Section 402, which relates to the taking of testimony versus an objection that can be argued based on this document. The reason I inquire of these matters is so that we can allocate sufficient time to deal with this. And the only reason we are dealing with it at all is that the defense had caused this witness to come here from out of the country. And the defense has requested that we accommodate at least that aspect of her proposed testimony to deal with whether there are any limiting issues that might arise to, I assume, give the defense an opportunity to evaluate whether to call her at some later time. Is that correct? You're not proposing to call her now in the people's case. My understanding was you just want to have a hearing under Section 402 to decide whether you will be calling her later.
You want to call her in 2 days. In our case, we wanted her to stay here an extra day. If we did.
After the people arrest you, man.
Yes.
Okay.
But we need you to order her back. That was part of the problem.
Well, if that's all you need me to do is order her back without a hearing, I'd be glad to do that. My understanding was that you needed to have some determination as to what she would be allowed to testify about before you keep her here.
Right.
Correct.
All right, so as I said, I want the people to review the document with your now stated intent to use these various items of evidence so that we can determine whether or not we actually have to spend any more court time on this by way of testimony, or it can be all be done by the document. Yes, you're going to say something?
No.
Okay. And then first thing tomorrow morning, I want the parties to inform me as to whether or not we need testimony and how long you expect that testimony to take. And in regards to witness Linhart, likewise, there was some prospect indicated at the sidebar that Mr. Burt will speak with Mr. Linhart and make a determination as to whether or not there will actually be need for a hearing under Evidence Code Section 402. And again, if there is such a need, I would want a time estimate from counsel tomorrow morning. So again, we can allocate time. And as far as Mr. Heffernan is concerned, which defendant is requesting the 402 hearing, and if you can specify whether or not this requires his testimony or just the reference to testimony from the grand jury transcript or reports or anything else.
I don't think it requires his testimony. I think we can base it on police reports and recent interviews.
Well, Your Honor, there's also the issue of the conversation on the plane back from Israel, which has never been resolved, the adoptive admission issue. So that still remains, but I don't think we will need testimony.
All right, that is contained in the police reports and/or the transcript, which is it?
He
The
didn't
grand.
testify before the grand
Okay,
jury, so
then,
it's a series of police
I've
reports.
read his reports somewhere. I guess it was in the People's Offer of Proof that was filed early in the. If there are other reports that relate to his testimony, then you ought to give me those so that I could have what it is that's going to be the basis of that hearing.
Yeah, there's a newer
I
one.
can give you the pages from our response to the people's motion to admit.
You know, you could, but you filed probably 2,000 or 3,000 pages worth of documents, and rather than my looking through all that, you can give me those particular pages.
That's what she said.
That's
She was
what I'm
going to
saying.
No,
physically give you
visit. Oh, I thought you said you were going to give me
No.
the page numbers to.
No.
Oh, okay, sure.
real
That's
pages.
good.
What about the last police report, the one that had the objectionable opinions, et cetera?
May I use the phone in the courtroom to call Mr. Linhart? He may be gone. If I don't get him, I'm not gonna get him here early enough tomorrow morning for his first time.
Sure. All right, well, let's, I think we've covered the territory as far as scheduling things here. So other than the defense obtaining the presence of a witness for the hearing relating to Eric Menendez spending, I think we've discussed all the other hearings that would have to take place outside the jury's presence.
You want to schedule Goldberg? He's available.
Well, I don't know about whether we'll have time tomorrow. As I said at the sidebar, I want allocate sufficient time so that the juries can have substantial time in the courtroom as well.
Well,
So,
all we know is he's on a 1-hour beaver for a civil trial, so
all right,
I
well,
guess he can't get too busy except in that trial.
yeah, he could be on that beeper for
4
several
months.
weeks. All right, we'll be in recess then until tomorrow at 9 o'clock.